Congratulations. Item number 121.
Yes.
Today's list. My learned friend was supposed to file it.
And I'm filing the counter today. I'm serving a copy. I have already intimated.
So,
Is there any stay or operating? Nice.
besides the proceedings.
Give it until next week. Next week I'll take.
You file a rejoinder, yes?
What in criminal matter rejoinder?
I asked that.
Counter is also not required. So I record that he has filed the counter today. 121. Mr. Marana has.
My friends are engaged. If my friend is in difficulty, 1 week after.
Okay. Mr. Marana has filed counter to the CRLMC. Also.
9th, yes.
And advance copy of the same is supplied to Mr. Palit, senior counsel. These the matter final. But there is a parental order, it seems. No further adjournment will be given.
Let it come along with CRLMC 2344 of 24. That is probably not in your.
It's the same case.
No, assignment.
Same academic asu. Say, I would tell you.
Assignment.
My CRLMC 2344 of 24. CRLMC is assignment. CRLMC. 3344 of 24. Till today is there. Till today, this is there with me. And let us list it on 9th. No, why are you going to do so? 29th. 20th or 29th. Then second December. Okay. And see, same parental order. Same parental order. That no further adjournment. Another matter 104. I'm sorry, my lord. 2012 ଆଉ 16 ମୋର proof ନଥିଲା ମୁଁ ସାଉଥ୍ ଲାଇଭ୍ ଯିବି ତେଣୁ ଟିକେ ମୁଁ list the list also. Which one? 104. Any date tomorrow ଆସିଲେ I'll do it. Tomorrow or Friday, any date. Tomorrow may not be possible. 22nd, 22nd. My lord. 22nd. My lord. 22nd. Friday?
My lord, I've been permitted to move for adjournment.
3 दिन का कथा है 3 दिन का
21.
21. Sir, काली आसु सॉरी tomorrow.
My lord, 119, my lord. 119, my lord. Number open number 2.
109.
109.
Yes. Interim order must be there. 2017 interim order. One, I am not on merit, but 2017. Then 22nd.
My lord, item 1.
No, 22nd. 2017. I have listed all these matters to vacate the interim order. I'll give it in January, no problem, but I'll vacate it.
My lord, item
22nd. Interim order.
Item 159.
159? Yes.
hearing का और कौन
59.
hearing तो अच्छी
This is hearing matter and take it up if possible. I don't think it is possible. And note the record whenever is there. I will complete. Don't worry.
100.
What do you want? One interim order is there. So then it will go. So it's all.
Sir, 19, my lord.
And then go the video data. Wherever there is an interim order, take it up immediately. If there is no interim order, it will go.
119, my lord. 119, my lord. And for the appeal number 2, I need 2 weeks time to file my reply.
19.
119, my lord.
119.
My lord.
What is this matter?
It's matter of passing the order, my lord.
In a criminal matter, what do you reply, count, rejoinder,
The
document you file and decide it.
OP number 2 is suffering from the kidney problem, my lord.
That is a true story. You don't ask for adjournment for on.
My lord, last time, my lord.
Interim order is there?
I'm for the OP number 2, my lord. I'm not for the.
You did you suffer interim order for another 2 weeks? Give it after 2 weeks.
My lord.
Give it. And petitioner, have you informed the petitioner?
Now I will inform.
I will come and say that I was not informed.
I will just inform.
Do you know who is the lawyer?
And
Who? Who is the lawyer?
there was his contact. He's appearing.
His name is not there, 119. No, रोकी नहीं तो चल स्लिप हो जाओ एडजन करो नो स्टे चलो एडजन
Person one,
58 next week not possible, next week only stay matters.
Lordship 100, please, Lordship. Lordship 133 and 134, Lordship. Lordship,
But that is in the weekly list.
yes, Lordship.
What do you want?
Lordship, can it be taken at 2 p.m., Lordship? Every time.
I have to adjust my board. You be ready. I can take it up by 3:30 if my board is finished. Okay.
Next one, 16. Next one.
Who is
16.
60?
One minute. Next one.
61 देखो क्या है? Press matter. Yes.
with your lordship's kind approval?
Yes, Mr. Mera.
One the CRLMC 4257 of 24. It's a compromise matter. These are allowed to be listed, but not listed.
What are the offenses?
Offenses, offenses 341, 307 is there. Other offense, available offenses are there. 307 is there. The matter has been settled between the parties.
Number 3. Okay. Give the number.
4257 of
Do you have any instructing counsel here? No? Give a memo.
just now.
We will forget.
Yes,
these
yes,
numbers.
I'll send.
Give a memo. Yes. Yes.
Item 55.
55. Yes.
Lordship's kind permission, I appear through VC in this matter for the petitioner.
Yes.
Lordship, this matter I'm seeking a short date. Essentially, Lordship Justice A.K. Mahapatra was leading this matter. I've received the briefs. I believe certain documents that my learned friend has filed.
You have challenged an order passed in the year 2012.
Yes, Lordship. This is a cognizance order.
2024. And now you are asking for adjournment. What is this?
Only 2 weeks.
No, show me the order first, imperial order.
Lordship.
And adjournment is not by way of right, sir.
I
Don't
understand.
understand. 2012 order you are challenging. 12 years. And now the matter is taken up, you are asking for adjournment. What is
Lordship,
this?
this is the first time I'm appearing this
Show me
matter.
the imperial order. Show me the imperial order. Where is that imperial order? 47? Yes.
Question of proceeding.
What is this imperial order?
Lordship, the difficulty is that the pleadings that I've received from my Lordship's office it's not complete. That is why I'm seeking a short date.
But
In fact,
you should have been vigilant about it. Cognizance is taken, cognizance of offense of 13-1, 13-2 and all is taken in 2012.
yes, Lordship.
I'm telling you. What is the stage of the trial? Trial might have been concluded.
Trial is proceeding. In fact, the petitioner is now retired as well. And Lordship, my only difficulty today is that what objections have been filed, that has not come on my file.
Tomorrow. Yes, next.
56.
56, tomorrow. Yes. 56. Somebody is there. I pass it over. Pass it over. Yes.
57.
Yes. PMLA. 57. What is the reference matter? Who's somebody sought for adjournment. This is the first matter? Huh? Adjournment. January. Let's January, February. Okay. 59. 59. Pass it. 60. 59? Okay. Yes. Yes.
In this case, the petitioner is the wife of the principal accused, and the petitioner is the house of knowledge, and the petitioner before a lordship challenging the questions that actually against the section 72. The petitioner maybe is not in the court, and this is her name is in the charge sheet, but none of the assets stands in the name of the petitioner, except some bank deposits, which was deposited by the husband, arising out of the judicial relationship minutes. This matter has been covered by the lordship in the instrument of the state of defense, not from solving the topic minutes. This is a covered matter minutes.
The charge sheet shows no assets in the name of the petitioner. Into deposit he is admitting. Some deposits are there. So
the petitioner also admit that.
So that I can because the charge sheet is covered. I will not finish.
Mine is a covered matter.
He is admitting that some deposits are in there. Is she putting forth any defense?
No, she is not claiming defense.
Then the argument is to explain.
I'm not claiming all.
I say I would like to discuss tomorrow from my side. Friday. He covered them why should to my what if she is not putting forth any defense? I'm convinced that it is covered. Yes.
Then stretching the matter because it's a covered matter.
He's saying that let me examine. Because you see, some deposits are there in your name, but you are not putting forth any defense to explain this thing. So then husband has to explain this.
That is arising out of judicial relationship. That's what they have
Right. Yes.
62. Madam. As instrument general is mentioning, mostly
Press matter, no. Press matter will come after in the January. No question of accommodating. Just no question. Either today or January. I am adjusting the board in such a manner. You can't ask adjournment. I pass it over. Pass it over. Very clear. Press matter, if it is listed, we are struggling hard to get it accommodated in the list. If you are asking for adjournment, we'll go to February. Stay matters next week or because there is a stay, I can't adjourn it. Very simple. No variation, no here or any.
I consider I consider
Please help me go. Because there are many matters.
I will put
it at 3 o'clock. No, 3 o'clock. Password. You want decision?
I can't sit.
But it doesn't look nice on your part. Actually, mobile देखिए आगे बोल देंगे और खाता कुछ December 62. Password.
64.
64 minutes. I am appearing from the present petition.
Sometimes it sounds very harsh, but what to do? The reality is this. We can recommend it tomorrow, day after, next week and all, but the harsh reality is, see, people are first time hearing is not taking place. We are adjusting in such a manner so at least they will get one hearing. If that is not happening, what to do? 600 matters, just imagine. First hearing, one hearing is not. So therefore, while request is made by learned lawyer, I want to accommodate, but it's not possible. That's the problem. Anyway.
64 item inclusive, the matter has already been compromised. The informant lawyer may say,
You compromise.
it has filed the compromise offenses in unit 363. He has only.
Call them, call them.
Who is the accused?
Susan Management Committee. Who is south? Who is the victim?
Victim is Melissa Subalakshmi. Ludhiana. But he was passed by one
Matter has already been transferred to Louisiana. Then how can I access?
Criminal cases are pending here.
Then what is transfer? The divorce petition.
Prime special,
Yes. What do you want now?
Well, also there was decided to settle the dispute, and I put
Issue notice to opposite party number 2. Have you included or not? Party number 2. Mr. Manti accept notice, waives notice for the state. These the matter. After 2 weeks or 1 week? Take out the notice immediately.
Yes.
After 1 week. Follow. After 1 week.
Then I will protect it. From page 50.
50? Okay. Then consider the petitioner submits that the parties, the dispute is arising out of a matrimonial discord, and the divorce petition filed by the husband.
Joint petition.
A joint petition. For wife has already been transferred to the competent court of jurisdiction at Ludhiana at the instance of the order by the Honorable Supreme Court of India, and the parties have then settled the dispute. Next paragraph. On 18/3/2020, NBW has been issued a but 18/3/20, the order is there. The accused persons are absconded. Issue NBW on 6/3, yes. 18/3/2020, NBW has been issued against the petitioners. Petitioner. Till the next date of hearing, the execution of NBW shall be kept in abeyance. And let them appear through DC. When? Friday? Monday? Then on 6th?
Yes.
6th December. 6th December, yes.
68.
Yes.
Yes. Similar case, you have already passed order in respect of another case here. You may kindly see this order. Where out of 10 cases, 8 cases inquired into by the SP on the application of the wife of the petitioner, where he has been exonerated from all 8 cases. The SP observed that except confessional statement, there is no evidence but this petition was wife. Your also has already passed order in respect of another case.
In that case also the wife of that petitioner has given.
No, same petitioner.
How many wives?
Total husbands.
There are one accused, you said the other day that my wife had given a complaint.
This is same accused.
अच्छा अच्छा सेवन सेवन so application of that the two cases you are there is this is the second case ଗୋଟେ କେସ୍ ଆପଣ କରିସାରିଛନ୍ତି ଆଉ ଏଇଟା ଅଛି ସେକେଣ୍ଡ ଆଉ ସେଇ ଯୋଉ ଡେଟ୍ ଅଛି ସେଇ ଡେଟ୍କୁ ଯାଉ ସେଇ ଅର୍ଡର କରିଦେବେ ଅର୍ଡର ଗୁଡ଼ା ଠିକ ସେଇ ଡେଟ୍ ଭୁଲ ଯୋଉ ଅର୍ଡର କପି ତ ଅର୍ଡର କପି ଅଛି ତ give that 4-4-7 এটা ଦେଖିଦେବି same order only no question actually because in this case warrant has not been issued that case warrant issued okay yes only this is changed this will be changed no question yes no question ठीक है yes
69.
the facts are there facts are set and FIR number will change FIR number change yes always yes 69 yes
Let's generate the order dated 23/9/2024. Let's you can see page 28, madam.
yes sir 28 yes
Page 28.
Yes.
Order dated 23/9/2024, madam. The occasion of this order arranged out of a petition filed by the learned counsel on behalf of the accused person in order to discharge petition, madam. From the alleged offence under section 341, 323, 294, 266 and 34 articles.
yes your application is dismissed okay
Rejected, madam. Therefore, see, ground that the evidence is over, that is the complete matter.
And after framing of charge.
Yes, after framing, last week.
not framing of charge
Framing of charge.
evidence is also over
Yes,
That's the discharge.
when the charge was framed
23/24.
23 judge frame
Yes, Lordship. Okay, page 27.
yes
that's we can.
you didn't tell in that order
Yes, that's we can see page 13, madam.
13 okay yes
Complaint petition, page 13.
yes
Page 13, para 4, occurrence took place 1.5 hours. We had not sustained injury. In the formal during of
para 3 you are reading
para 4.
Para
Page 13, para 4.
13 okay yes
We had not sustained injury in any.
occurrence took place for 1.5 hours
1.5 We had not sustained injury, madam.
for around during
Any form during occurrence, madam.
we had not gone to
They are now
Hospital.
gone to the hospital. Then I, along with my husband, came to the PPDPS. So now day of occurrence, we rejected. Let's see, time C, page 17, madam.
yes
Deposition witnesses number 2, madam. Para 2, madam, last.
yes occurrence took place on
I did not
Public road?
any injury, madam.
they along with my wife and were going to come through all the equations of suspects as into application from through I did not sustain any injury
Yes,
okay.
madam.
yes
Para 4, last page 18, madam.
yes
Para 4, while accused Golas Malik was standing gold chain from neck of my wife, it was.
he has also not sustained any injury
That is general.
yes
In this case, my lord, the opposite party number 2 also stated that initial statement, my lord, occurrence took place in her agricultural land, my lord. And again says on the way in her complaint, the person says that accused person are obstructed on the way. So that is the discharge that the cognizance is taken is the offense. You know, just injury 323. The injury kichi nahi.
no, these are the statement of one witness what about the other witnesses might have said
That's not the point.
That is
There is a case, arising out of one complaint case also. After framing of this charge, the present person will file. In the discharge petition,
no what he says is in the complaint as well as in the statement of 202 he very specifically says he has not sustained an injury then where is 323 that's what he says
I want to finish question.
you show me any other witness have said anything
But evidence is not with me.
where are the other witnesses
last.
and all witnesses are there
OP2 is the receipt party will be no office.
Now,
There is a complaint case. Notice will be go to the 2 hours.
Come to page 18. Read para 3.
Person Koyas Malik and his son named Hariar Malik or hold my wife. From our back and which Koyas Malik snatched away one gold chain put in 2 bari from the leg of my wife. I had purchased that gold chain from Ipari Govina.
Yes, that is the reason 323. You may not sustain injury from the neck, you have pulled the chain. You might not have such an injury, doesn't mean that 323 will go like this. So that's the reason rightly done.
341, there is 340.
The prima facie materials are there. Nobody can help you.
And he 23 not out my.
330 made out, sir. I don't know. It may not be visible. Because she was wearing the chain and you pulled the chain from the neck.
The injury, no injury.
It's not necessary injury. See, these are the witnesses. Right also. These are the witnesses. They are not the doctors. Intra-injury, how do I know? But this is some lady is going in the road. You are putting the chain from the neck.
Nature, agricultural land property.
I will not appreciate the evidence.
Yes,
I will not appreciate the evidence. No. There you go. 202.
It's been noted to up to 2 hours. There is no complaint.
If you settle, I'll do it. Beyond settlement, I will not.
Settle.
Shall I record that you are going to settle?
Settle can call for the city.
Only on that ground I need to notice. Otherwise, you don't have to. Because you have snatched the chain. That is a good idea.
Yes, sir.
Instead of doing that, because otherwise you made case is made out. You snatched the chain of a lady. I know. Then counsel for the petitioner, although says the order dated 23/19/24 passed by Leonard JMFC Pipli in ICC case number 101 of 2023, whereby his application for discharge has been rejected. However, he submits that the parties being related to each other may settle the dispute. May settle the dispute, and the petitioner is making all endeavors in that direction. Issue notice to opposite party number 2 written upon the take.
Stay of the further proceeding.
No, stay. Shall I send you to mediation?
And mediation stay of the further proceeding. Stay say mediation for
the case is made out. You have not challenged the charge. You know the discharge application subsequently, which is rejected. How can I say this? You don't have a case. See, I'll send it to mediation, then I will stay. Yes, Mr. Mate, I'll send it to. You take out the notice, put it on 22nd. Take out the notice. Take out. Yes.
70.
File the process, sir, immediately. Today, executive file so that 22nd would. Yes. 70.
Your Lordship,
Yes.
Lordship, I'm challenging the order of conviction and sentence passed by learned
What is the sentence?
Yes. Total of areas
Undergone?
undergone is 25 days.
21 days.
21 days.
Feel admitted. The bail, are you in custody now?
Yes, my lords.
Perfect. Bail granted. Realization offense 2 and call for TRC. List Mr. Sanjay Das name. So same paragraph. Yes.
May I pray before your lordship that this matter may be listed after receipt of the TCR. Because today
This matter after receiving
receiving of the TCR, because all the matters which have been listed, I think that all the TCR is received.
TCR. Release the matter for hearing after the TCR is received. Yes.
71.
Most of the citizens get notes. The applicants have come to number section 32, 39, so the customer. And amount 409, 416, IPC numbers.
Yes.
My lords, they are on the hearing and the sentence, my lords, is at page 78 to 78, my lords.
Yes. What did he sentence?
My lords, criminal misconduct, my lords, 13, my lords. of prevention of corruption act.
Sentence, what are the sentences?
It's rigorous imprisonment for 1 year for the commission of offences under section 13 to 39 schedule of PC Act 1988, 409, 34 IPC, and to pay rupees fine of 10,000 dollars.
So what do you want?
That's I filed for IA and
Rigorous punishment, I will make it too simple. Are you happy?
no matters. They are
I'll make it simple.
unless they're filed for
Rigorous imprisonment which is awarded by the court, you know, I will make it simple.
no.
Okay, there.
My lord, here six appellants out of 7.
My lords.
6 appellants have filed this common appeal.
Okay.
My lords.
Appellants petitioners are 6 in numbers.
Okay.
Out of 7.
And
Right.
the appellant, huh? 6 appellants. Appellants, appellants. You must be 389 penalty might have been given less than 1 year, no? Less than 1 year, less than 3 years.
All of them are above 72 years.
My lords.
468,
69,
34 is there.
65 and all.
468, 34 is there. 31 C is there.
My lords.
Admit karo. Bail, stay of relation fund. Release the matter after TRC is called, huh? Yes.
And both the matters free copy given.
Free copy. Give the free copy.
Is the lord.
Copy of appeal to, now you got it, na? Yes, copy of appeal which they filed, you got it?
Yes.
Yes. Yes.
Only free copy today.
Free copy to got, yes.
May I please your lordship? Item 72, this is an urgent bail application fasted for orders today by this Honorable Court dated 4/11/2024. The lordship had directed the Learned State Council to obtain criminal antecedents as well as the CD of the present petition.
Yes, do you have?
It is available for antecedent parties cancel the petition of sale. That has not been obtained for the acting lordship. It is done tomorrow. In the meantime, I will obtain the super antecedent.
Why you people are so slow to get the
No, this
instruction?
is available with my seller. So for antecedent in the
I'll put it next week. Huh?
Your lordship.
Yes.
The lordship kindly be posted it day after tomorrow if my learned friend is stating it.
I don't know. I'll put it again. We'll ask for adjournment. Better that next week I put it in the sense. Let it be on 26th. 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 Huh? Oh. I'll adjust it and go.
Lordship.
So that it will not be adjourned at least.
Your lordship.
To decide it. Yes.
73.
May I please, my lord?
Yes.
My lord. The present person in custody since 8/1/24. Liaison is 8/1/24.
Matter you are prepared.
সেটা বেশি অন কো-অ্যাকিউজ অ্যাকুইডালি দিলে সে প্রোডাক্ট মাইনর সার্জন আর দ্য আদার
Yes. Secretary
custody 8th January 2024.
24. Okay.
It is alleged that on the date of alleged incident, one person has been kidnapped by the accused persons, not by present accused, by other accused persons. And they confer and they have demanded sum of rupees 1 lakh.
Yes.
They have told that the son-in-law has told the deceased, who is the father-in-law, namely Purnachandra Pradhan, to come with rupees 1 lakh. If they come with rupees 1 lakh, they will and they get him free. And if 1 lakh, Madam Pradhan and Purnachandra Pradhan went to the place, as per their direction, they went to Bakala High School. Bakala High School, there was a person between the accused persons and the deceased and the informant. And the present petition is not the asylum.
Yes.
You all are in Duncan stage.
What are the charges?
Charges
302.
302.
Change that.
Yes, Your Honor. There is the eyewitness which one. Nirandra Mahathir is the eyewitness.
Read it.
Very much case.
Read. I will say.
More now Nirandra Mahathir for আজি 5/5/2024 মনমুন্ডা পুলিশ অভিযান দেওয়া মোর মৌখিক বয়ান এইকি যে গত 3/1/2024 রাত্র প্রায় 7টা সময়ে মোর ভিণেই পূর্ণচন্দ্র প্রধান মতে ফোন করি কইলে যে তোর জয়েন্ট পরমেশ্বর মহাপুর ବରଛନ୍ ମହାକୁଡ ଗ୍ରାମ ଖମା ଥାନା କଣ୍ଟାମାଳ ଜିଲ୍ଲା ବୌଦ୍ଧ ଦପଳା 1 ଗ୍ରାମର ଚୈତନ୍ୟ ମହାକୁଡ ପିତା ରାଜେନ୍ଦ୍ର ଆଲିଆ ସୁରୁବାବା ମହାକୁଡ ଓ ଆହୁରି 5 ଜଣରୁ ଅଧିକ ଯୁବକ ତାଙ୍କୁ ଅପହରଣ କରି ନେଇଛନ୍ତି, ଜ୍ୱାଇଁଙ୍କ ଅପହରଣ ରିସିପ୍ଟର ଜ୍ୱାଇଁ, ଏବଂ 1 ଲକ୍ଷ ଟଙ୍କା ଦେଲେ ଛାଡ଼ିବେ ଅନ୍ୟଥା ମର୍ଡର କରିଦେବେ। ଏଣୁ 1 ଲକ୍ଷ ଟଙ୍କା ଧରି ଦପଳା 1 ଉଚ୍ଚ ବିଦ୍ୟାଳୟ ସେ ଯାଉଛନ୍ତି ଏବଂ ମୋ ସଙ୍ଗେ ଆସ ବୋଲି କହିଲେ। ଏହା ଶୁଣି ମୁଁ ଦପଳା 1 ଉଚ୍ଚ ବିଦ୍ୟାଳୟ ପାଖକୁ ଗଲି। ସେଠାରେ ମୋର ଭିଣେଇ ପୂର୍ଣ୍ଣଚନ୍ଦ୍ର ଠାରୁ ଚୈତନ୍ୟ ମହାକୁଡ ଏବଂ ଅନ୍ୟମାନେ ପଇସା ନେଇଛନ୍ତି ଆମ ଜ୍ୱାଇଁ ପରମେଶ୍ୱର ମହାକୁଡକୁ ଆଣିବା ପାଇଁ, କିନ୍ତୁ ସେମାନେ ଆସିଲେ ନାହିଁ କି ଜ୍ୱାଇଁଙ୍କୁ ଆମର ହସ୍ତାନ୍ତର ନ କରିବାରୁ ମୋର ଭିଣେଇ ପୂର୍ଣ୍ଣଚନ୍ଦ୍ର PCR କୁ କଲ୍ କରି କହିଥିଲେ। PCR ଗାଡ଼ିରେ ମଧ୍ୟ ଥାନାର ସାର୍ ମାନେ ଆସି ବୁଝାବୁଝା କରି ଆମ ଜ୍ୱାଇଁ ପରମେଶ୍ୱରକୁ ହସ୍ତାନ୍ତର କରିବା ପାଇଁ କହୁଥିବା ସମୟରେ ଚୈତନ୍ୟ ମହାକୁଡ ତାର ବାପା ରାଜେନ୍ଦ୍ର ଆଲିଆ ସୁରୁବାବା ତାର ସାନ ଭାଇ ଶ୍ରୀତମ ଏବଂ ତାଙ୍କ ସହ 4 ରୁ 5 ଜଣ ମୋଟର ସାଇକେଲରେ ଆସି ପ୍ରଥମେ ମନମୁଣ୍ଡା ଥାନାରେ ସାର୍ ମାନଙ୍କୁ ମେଢା ଲୁହା ପାଇପ ଇତ୍ୟାଦି ମାଡ଼ ମାରିଲେ ଏବଂ ତାପରେ ମୋର ଭିଣେଇ ପୂର୍ଣ୍ଣଚନ୍ଦ୍ର ଓ ତାର ସାନ ଭାଇ ମଦନକୁ ମାଡ଼ ମାରିବା ସମୟରେ ମୁଁ ସେମାନଙ୍କୁ ଛଡେଇବା ପାଇଁ ଯିବାରେ ସେମାନେ ମତେ ମଧ୍ୟ ପାଇପ ଧରି ମୁଣ୍ଡ ହାତ ଗୋଡ ଯୋଉଠି ପାଇଲେ ମାଡ଼ ମାରି ଚାଲିଲେ। ଏହା ଦେଖି ମୁଁ ଜୀବନ ଭର ଦୌଡ଼ି ପଳାଇଲି। ସେମାନଙ୍କ ମାଡ଼ରେ ମୋ ମୁଣ୍ଡ ଓ ଅନ୍ୟାନ୍ୟ ଅଙ୍ଗ ଫୁଲି ଯାଇ ଭୀଷଣ ପୀଡା ହେଉଛି। ସେମାନଙ୍କ ମାଡ଼ରେ ମୋ ଭିଣେଇ ଚନ୍ଦ୍ରଙ୍କ ମୁଣ୍ଡ ଆଖିରେ ଗଭୀର ଭାବରେ କ୍ଷତାକ୍ତ ହୋଇଥିବା ବେଳେ ତାଙ୍କୁ ଗୁରୁତର ଅବସ୍ଥାରେ ପ୍ରଥମେ ସୋନପୁର ମେଡିକାଲ ପରବର୍ତ୍ତୀ ସମୟରେ ବୁର୍ଲା ମେଡିକାଲକୁ ଚିକିତ୍ସା ପାଇଁ ସ୍ଥାନାନ୍ତରିତ କରାଯାଇଥିଲା। ତାଙ୍କ ଅବସ୍ଥା ଅତ୍ୟନ୍ତ ଜଟିଳ ହେବାରୁ ଭୁବନେଶ୍ୱର କ୍ୟାପିଟାଲ ହସ୍ପିଟାଲକୁ ନିଆଯାଇଥିଲା ଏବଂ ସେଠାରେ 5/1/2024 ଦିନ ସକାଳ ସମୟରେ ତାର ଦେହାନ୍ତ ହୋଇଯାଇଛି।
Sandeep Malinga. Sandeep Malinga. You must be along with these 5 people. Anybody is taking?
Yeah, so I am reading the disclosure statement.
What is the evidence against Sandeep?
Yes, sir. Yes, sir. So I am reading the disclosure statement. Accused was before the police. Chaitanya Mahakudu. He has stated the name of the.
Who has taken the name? Yes.
Chaitanya Mahakudu, one of the accused in this case also. Adita charge disclosure statement. Adita charge is that we from the Panthera from the Mona police has
Relevant party read, don't you?
12,000 ଟଙ୍କା ଦେଇଥିଲେ ପରମେଶ୍ୱର ମହାକୁଡ ତାର ଟଙ୍କାକୁ ନ ଫେରିବାରୁ ଗତ 3 ଉପରବେଳା ସମିତ ମହାଲିଙ୍ଗ ସାଙ୍ଗରେ ମୁଁ ମିଶି ତାର ଗ୍ରାମକୁ ଯାଇ ପରମେଶ୍ୱରଙ୍କ ଘରେ ସାଇକେଲରେ ନେଇ ଆସିଲୁ। ତାଙ୍କୁ ସାମ ଦନ୍ତାର ବାଡି ପଟେ ଥିବା କପା ବାଡିରେ ରଖି ମୋର ସାଙ୍ଗ ମନୋ ପୃଥ୍ୱୀରାଜ ପ୍ରଧାନ ମୋ ସାନ ଭାଇ ଶ୍ରୀତମ ମହାକୁଡ ସେଠାରେ ଡକେଇଲୁ। ପରମେଶ୍ୱରକୁ ଟଙ୍କା ମାଗିବା।
What is his name?
No. You
read the statement of Koiki.
Yes, sir.
Okay, Koiki statement. And
ପରମେଶ୍ୱର ଟଙ୍କା ମାଗିବା ବେଳେ ତାଙ୍କୁ ମାରି ଦେବାକୁ ବୋଲି ଧମକ ଦେବାରୁ ସେ ତାର ସ୍ତ୍ରୀକୁ ଫୋନ କରି ଡାକି ଆଣିବା।
what is recovered from him?
Yes, sir.
Except Koiki statement, what else you have against him?
This is clearly stated before the magistrate that the present prisoner is involved in the alleged.
Who? Koiki.
Son-in-law of the present decision. That his name is Parameswar Mahakudu.
You read his
Yes, sir.
statement. Where he has taken them. He is also an injured witness.
Yes, sir.
He is also an injured witness.
Yes, sir.
Eyewitness and injured also. Yes. Read that part. That part where
Yes, sir.
name of this accused.
ମୁଁ ଆଜି ତା ଏକ୍ଚୁଆଲି ଉପସ୍ଥିତ ରହି ବୟାନ ପୂର୍ବକ ଏମିତି ଯେ ଯୋଉଠି 1/2/2024 ଦୂର ରାସ୍ତାରୁ ଶ୍ୟାମ ଦନ୍ତା ଠାରୁ ମୋର ଜରୁରୀ କାମ ପାଇଁ 12,000 ଟଙ୍କା ଆଣିବା ପାଇଁ ଚାହୁଁଥିଲି। ଏଇଥିରେ ସେ ଧାର ଦେଇଥିଲା। ଏଇ 5 ଦିନ ପରେ କହିଥିଲା ଯେ 3/11/2024 ଦିନ ସକାଳେ ମୁଁ ଶ୍ୟାମ ଦନ୍ତାକୁ ସାଇକେଲରେ ଆଣିକି ଦେଇଦେବି। ସେଇଦିନ ଶ୍ୟାମ ଦନ୍ତା ସମିତ ମହାଲିଙ୍ଗା ଓ ଚୈତନ୍ୟ ମହାକୁଡ ମିଶି ଆମ ଗ୍ରାମକୁ ଯାଇ ମଦ ଖାଇ ପିଇବା ବୋଲି କହି
Samit Malinga, name is there.
yes sir ସମିତ ମହାଲିଙ୍ଗା ଚୈତନ୍ୟ ମହାପ୍ରଭୁ
Let this witness be examined.
Neither, Coram sir, Mahathir is now occurrence.
Yes, my lord, I am for another bail applicant in this case, another petitioner, Manoj Danta. My lord, in the meanwhile, the main eyewitness who was also an injured, that is Madan Pradhan, have already been examined before this court, before lower court as PW1, my lord. And during his deposition, he has started nothing against these two present petitioner, my lord, not even a single word.
Where is his testimony?
Before district court. My lord, I have already filed the deposition copy, PW1. Manoj Madan Pradhan, my lord.
Show me that part.
It is filed.
I have a copy of this the testimonial of
The you are relying upon one eyewitness. That eyewitness has not supported you. And next evidence is co-accused statement. Co-accused statement is neither here nor there. No recovery will affected the insuperative accused concern. What else you have? And the case is serious. 302 and everything is there. Offenses are serious.
Forming of the present decision lordship and the very much eyewitness is present in the time of the occurrence.
That eyewitness is not supporting you,
I have
sir.
not gone through the statement of the PW
When I am given.
lordship. Let it come just now. This is the copy of the deposition PW 1.
Give it 20.
My lord, in this case, the son-in-law was not. In this case, my lord, son-in-law was not the eyewitness. The sole eyewitness was Madan Pradhan, my lord. PW1.
Sir, how many witnesses have already been examined?
Seven, my lord, seven.
Where are the witnesses? Do you have that?
Yes, my lord. I have. I have submitted.
When was he examined? August.
Nobody has stated even a single word against this petition, two petitioner, my lord.
That's the root nature of the
Yes. If these witnesses have been examined on 29th of August 2024. Okay, all the witnesses, 24 September, August and all. And all these things are there before trial court. Why don't you remove a bail there? Why should I go into all these things? All the witnesses are there right out. The petitioner is agreed by the order dated 1 minute. Order dated 18/4/2024, whereby the bail plea of the petitioner, only petitioner, has been rejected by the Court of Additional Sessions Judge, Special Judge Kandamal. Thereafter, on 29th August 2024, on 30th of August 2024, and on 29th, 30th August, and on 30th August, September week, and 24th September 2024, 7 witnesses have been examined. Out of them, 7 material witnesses have been examined. In view of the same, I am not inclined to entertain its bail application at this stage. However, the liberty granted to the petitioners to renew the bail plea for the trial court. If such bail plea is moved, the same shall be considered in the light of the evidence which has already been adduced by the prosecution. With this yes. Yes.
74.
And the same shall be considered within 15 days. Yes. Within 15 days. Yes. The bail application shall be considered within 15 days. Move the matters disposal. Yes. The witnesses are not supported. Within 15 days, you will get the bail. Yes.
74 on the last occasion, Lordship had directed me to file an affidavit with regard to the antecedent part, my lord. The petitioner has got 2 antecedents. I have applied for those copies of the bail, and Lordship may kindly keep it to some other day so that the affidavit and the bail order will be filed.
Okay. Then, I'll just.
Lordship may keep it to first week of December.
First week. Okay. Okay. Yes.
Your Lordship, in item 75, I'm appearing for the petition to VC. Your Lordship, this is coming up for the second time. And last date, Lordship directed for the CD.
Yes. Have you got the CD and all?
No, not page 32 in charge sheet.
Yes.
The paragraph starts from the unsustained interrogation in presence of witnesses. Accused person namely shown to Dharmendra Kadra also that he has no cultivable land, he is landless and we can ambition to get more profit by sale.
What do you want to say?
I want to say that further, last line, further the statement of accused person was recorded under section 57. That document
Get the copy. Yeah. CD is not there. Call for CD. Yes.
Lordship, may give me a shorter date because I have been.
Yes. We adjusted. Give it. Yes.
76.
I'm obliged.
No, yes. Lordship's last occasion has called for the CD.
CD is there? Yes. Ready? Yes.
The offense under section 457 and the 395. The antecedent they are.
Antecedents?
No, Lordships. How many? 5 antecedents, Lordship.
Have you filed those things? Have you filed an affidavit?
No, Lordship.
File an affidavit. Antecedent file. Yes.
So, Lordships, the co-accused item was at 74. It may kindly be taken up together.
74 and both the matters will be taken up together. Meanwhile, the petitioner will file an affidavit giving the details of the cases he is involved and the status. Yes, 77.
7.
Please, Your Lordship. This is successive bail application, my lord. Earlier, the petitioner was approved before this.
CD is there?
Yes.
Yes.
My lord, the allegation of 302, the FIR was lodged, but subsequently in the charge sheet, my lord, there is 498, 304B, 4 of Dowry Prohibition Act, 306 and 406. That is a suicide, my lord, there.
Yes.
I have filed the charge sheet, copy of the charge sheet.
Husband?
Yes, my lord. Except the husband, all are discharged in the charge sheet, my lord.
Sorry?
Except the husband, well, all the accused person who has named in the affair, they have been discharged.
Show me the charge sheet.
Well,
you are in custody since?
Well, custody since 17/12/2023.
23, okay. Show me
Well, the postmortem report I have annexed, my lord, case 34. No external injury, my lord.
Let's see the first allegations.
Well,
what is the charge sheet?
The charge sheet is, my lord, 31. It starts.
What are the allegations against the husband?
Well, allegation is that he was demanding, my lord, as per the FIR, my
No,
lord.
demanding forget. What are the incidents?
The incident is the charge sheet, my lord. Page 31. 32, my lord. Investigation is. It is ascertained that complainant Vishnu Charana Singh, the father of the deceased, is the permanent inhabitant of the company.
Come to relevant part. Why are you reading everything?
This is the Manmohan, the second daughter of, in other hand, Prabhakar Das. And it also permanent evidence. Hon'Ble, Kanucharan Das is the later one. And the case is supervised by so-and-so.
Come to the relevant part, sir.
Yes.
Why are you reading so many things? On the date of incident, what had happened?
On October 2023, the date of incident.
Yes.
When the complainant got a call from father-in-law of his daughter, he stated that his daughter is sick and now admitted to DHH Jajpur. When the complainant went to DHH Jajpur, he found that his daughter was died and lying on the bed. The complainant also noted the few injury marks as well as a deep black ligature mark on the neck of her daughter Manorama. During course of investigation as well as examination of PW, it is ascertained that it is a true case of 498A, 304B, 306 and 4 DPR against the accused
husband namely Venugara Das, the Chidia, son of so-and-so. This case is supervised so-and-so, and the now evidence impending complexity. FIR name, father-in-law Prabhakar Das, mother-in-law Jharana Das, and brother-in-law Kanucharan Das, and sister-in-law Meera Das, brother-in-law so-and-so.
How she died?
Submitted full compliance report, and I submitted preliminary charge sheet by so-and-so. The trial to stand in the trial in the court of law, keeping investigation open as per under section.
Mr. Vishal, you are reading, not reading relevant part.
Well, page 35, if your lordship will kindly have a glance. The postmortem report, the opinion of the doctor.
How she died? Hanging.
The hanging melon.
The door was bolted from inside?
No melon.
Anything?
That was open.
Huh?
That was open.
Statement of Miradas. Statement of Miradas.
Read it.
What now Miradas? The relevant part I am giving. ସେହି ଅଧା ଗଢା ଘରେ ଏକ ରୋଷେଇ ଘର ସହିତ ଏକ ନଳକୂପ ମଧ୍ୟ ଅଛି। ଗତ 17/12/2023 ତାରିଖରେ ମୁଁ ଗାଧେଇ ଯିବା ସମୟରେ ମନୋରମା ଗାଧେଇ ଯାଇଥିଲି। ସେଥିପାଇଁ ମୁଁ ଘରକୁ ପଳାଇ ଆସିଥିଲି। କିଛି ସମୟ ପରେ ମୁଁ ଯାଇ ଦେଖେ ତ ସେହି ଅଧା ଗଢା ଘର ଏକ ଲୁହା ରଡରେ ବେକରେ ଶାଢୀ ଲଗେଇ ଝୁଲିଛି। ମୁଁ ଏହା ଦେଖି ଚିତ୍କାର କରି ଡାକିଲେ ଆଖପାଖ ଲୋକ ଆସି ମନୋରମା
and the medical report. The postmortem report, the opinion of the doctor in the postmortem report reads as under para page 35. Page 35 opinion last. Page 35 opinion last. And the postmortem report also reveals that there is no external injury sustained by the disease. The petitioner is already in custody since 17/12/2023. Regarding to the nature of allegation and the fact that the charge sheet has already been filed against the present petitioner alone, exonerating the other in-laws from the exonerating the other family members, and the petitioner is already in custody for about 11 months. For 11 months, I'm inclined to allow the petition on bail. Yes. Yes.
78.
May I please, Your Lordship?
This one. Yes. You have got the CD along? Yes.
The petitioner's custody since 1/7/2023.
1/7/2023,
Your Lordship.
1/7/23. Okay.
Earlier than petition moved to application, Your Lordship directed to move after submission of charge sheet, and accordingly this application filed.
Yes.
The charge sheet submitted under section 364, 302, 201, 120B, 34 IPC, Your Lordship.
Yes. Okay. Yes. You are the known?
Sir, I am Bidika.
Yes.
Fact remains, Your Lordship. One Rajiti Krishna.
He has come to the charge sheet. What are the allegations against you?
My Lord, the page 15 is the FIR, Your Lordship.
Yes. FIR forget. Come to charge sheet.
Yes, Your Lordship. Charge sheet is at page 20, Your Lordship. And the brief fact that is at page 33, Your Lordship.
Oh, that matter. I know. You have given supari to someone and all.
I have not given supari. That is my case. What my learned.
What about the other matters? All the matters were listed. It's a connected matter.
Set up bicycle.
Bicycle. Prepare a chart. What are the allegations against which accused?
Yes.
And what are the material you have? Because
only matter the confession of the main accused Rajit Krishna. On his confession, the present petition has been implicated.
If I exactly remember, the story is, Supari was given to supervise someone, killed, and the Supari money was not paid. He went there to Andhra Pradesh and gave them up. That is this is the Rajit Krishna. Rajit Krishna, he has given Supari to the present deceased to kill one Gaurimon, and he has done his duty and they killed the first FR. Thereafter, Lordship, after their act is committed, Lordship, the deceased asks money to Rajit Krishna, and Rajit Krishna called him to Visakhapatnam, and there he has killed the present deceased. That is the case, Lordship. And so far the allegations against the present petitioner, nothing is there. My name is not in the FR, Lordship, and only on basis of the confession, that is 27 evidence act, so far the recovery part is recovered from you. Rossi Jutre Marichanti, say Rossi recovery, rusted gun recovery from the stage of the trial. To खाली चार है चे किसी है नहीं बतन बसे ऊपर रहे हैं ट्रायल स्टार्ट है 20 सेकंड ओके यस नेक्स्ट भाई
79.
Prepare a chart, insofar as that matter is concerned. Yes.
Yes. This matter two bail before one before charge sheet, another is after charge sheet, my lord.
Yes.
That bail I withdraw by mentioning, but some mistake that is not withdraw.
Yes.
Allegation is, my lord, 457, 395, 170, 327. Yes, my lord.
Yes.
In this case, co-accused person released on bail, my lord, by trial court, my lord.
What are the allegation against you people?
Allegation is same, 8
Deepak Pradhan and Harishchandra Connor.
8 person came and assaulted and taken away some gold ornaments and cash. Thereafter,
what are the allegation against you?
Sworn allegation.
Let us see. What are the allegation against Deepak Pradhan and Harishchandra? And other co-accused persons have got bail. Who all are they?
All are caught by the local man and seized all ornaments and
totally how much? You examine it. Okay.
We have caught and
okay, please it.
yes, madam.
Yes. Yes, next.
80.
Placing your lordship's memory, I have been implicated on the basis of the co-accused statement. Occurrence took place on 9/7/23. I was arrested on 13/8/2024. 13/8/2024. Charges submitted on 5/1/24. And last time the lordship was pleased to direct the State Council to get the CD as well as the.
Have you got it? CD. Okay. Please sit. Day after.
Day after 9.
Huh?
Day after I am having.
Next week. Next week.
No, Friday.
Friday. Okay.
Okay.
Friday, huh? Friday. Okay.
81.
Yes.
Last occasion, we also directed the State Council to obtain the CD. I have also given the reference in which the CD was available.
CD, you got it.
Well, you lost me, can you sue this? I given the reference and told them how to get the CD and how to attach this.
Now you assist you were that side, you know.
And you lost knows that if this will happen.
Last of parliament, what is saying? The last do whatever I got to say part. In many cases, my lord, they have not written letter anything to the IO. So we are bringing the files and now we are sending letters.
Good. And in the process, I will put it next week.
It's a process, no. That is not the process. That is not the process.
Anyway,
after certain, it how to work, Miller. I'm saying, Miller, because I have experience. Saturday,
right letter.
Because I was complying the lawsuit's order. Your lawsuit, remember, what we are doing in Saturday and Sunday, the brief were assigned to us. And we are finding out in which case CD was not there or what instruction we have to carry out. Then on Saturday, Sunday, we complied by telling the IO, INC every day. And by 2:30 night, we used to sleep. To my experience in here. This was my hard work. That is why I was complying.
In one case, the IO was not complying with their instructions was not giving. I called him to appear in the court. From somewhere, from the Malkanvi or somewhere.
And in the no time when he appeared and complied all the documents.
Therefore, if you have any problem anywhere, you tell me so that we can.
By the process, this will not be compared to him. We will suffer because the client will suffer next week. Without about.
But I don't know what is that.
Sufficient.
I don't know what is. I'm only giving 1 week time, and I have already told you that I will accommodate only for from today. I was not supposed to accommodate you. Last time I told you. I called you to my chamber and told I am not accommodating. No, but you had taken a 15, 20 days. You have already taken.
Marriage is there. The Rostam can you fix up at 26th?
26th. Okay.
26th, the Rostam.
26, 27.
Yes.
Yes. I'll just come. I'll just come. 5 minutes. Very bad practice. The order you are agreed by, that order you are not. 17/8/2018. When this petition was filed? 20th. When you filed this petition? 20th August 2018, my lord. 20th August 2018, my lord. 18. 20th August 18. As for the reasons stated in the petition, the sale is allowed. The CRLMC, na? CRLMC. What is that? CRLMC? Huh? Simple. No. What is the original petition? CWP. No. Only this application is there. Yes, the reason stated in the application, the CRLMP is allowed, and writ petition civil number 4194 of 2010 is registered to its original file. Lease the matter for lease the writ petition for hearing before the appropriate bench. After everyone approved the honorable Chief Justice. Yes. Oh, last one.
83.
Well, the sales were dismissed due to non-prosecution matter. Due to non-prosecution, it was dismissed. At para 2, I have heard that matter on the day of listing. It was listed on 5/5/2023 matter. On that day, matter I was held up in court. That was it was coincide.
Is there any delay?
No.
No.
For
the reason
dismissed on 5 months, I have filed.
The CRLMP allowed, and CRLMC number 4729 of 2011 is restored to its original file. Lease the matter for hearing. Yes.
84.
Yes.
This is my lord. Last occasion lawsuit directed. If I will satisfy your lawsuit, then your lawsuit will restore this application. This is dismissed for default. Filed for restoration, and your lawsuit. Yes, that is true. And your lawsuit directed me to, if I will satisfy your lawsuit, then your lawsuit
on merits.
Yes, on merits. That is why this application has been posted today for a hearing.
Yes.
Now my lord, lawsuit may kindly see page 7 units.
Page 7 of
the main application.
CRLMC.
CRLMC.
Yes. Page 7. Okay.
Page 7.
Here.
Lawsuit may kindly see order dated 18/9/2017.
Let us see. Let my understanding. Yes.
18/9/2017.
Yes, I'm there.
The accused namely Ramakanta, up to 2 lines. The accused namely Ramakanta Patnaik alias Papuni, son of Shraddhakanta Patnaik of village post Bolgad, district Khurda. You also got it? Now you also can turn to charge sheet.
Yes.
Charge sheet at page 17.
Yes.
Ramakanta Patnaik, son of Shraddhakanta Patnaik.
Yes.
Village address, just below the address, Bolgad, PS Bolgad, district Khurda. Now you also can return to who am I? Yes, who am I? But I have given my all certificates. I am an advocate of 20-30 years practice. Ranpur Bar Association. You also may kindly see page 25. 25.
Yes.
Let's look at it. Ramakanta Patnaik, enrollment number 421/95/2009. Let's look at it.
Yes.
Ramakanta Patnaik, son of
Ranpur district land.
Total different. You also can say son of Shamavan Patnaik.
Okay.
At Rajram Ranpur, 4th Ranpur, district Noida. This is district Noida, village address, all separate. The accused is from Khurda, another district. But police is apprehending me that you are the person, Ramakant Patnaik. But that is why this application was filed initially before a loss, this honorable court, and after.
You are saying it is a mistaken identity.
it is a mistaken identity that I am not that person. I am not that person. And how, and what circumstances, my lord, the police is appending, that is why long after a long hearing, these court are being satisfied.
You are agreed by what?
This proceeding, my lord, I have challenged this proceeding, my lord, page 7, issuance of indictable.
I'll go and appear there.
No, I'm not saying that. You lost it, can you see? I'm not the accused.
You tell all these things. 482 court can't.
This is what
You go and tell all these things to the trial court. NBW issued past the NBW will allow you to go and appear in the court and do it. I'll allow both your application.
I know this. Yes, I know this. But I want, when I am innocent, I am no advocate of any. Which is evidence has to be made.
That way you establish that it is a case of mistaken identity. Process and go and tell I will cause the NBW order and go and appear.
You also mentioned that I am not the same.
I'll record your statement.
Yes,
I'll record your statement. Yes. This is in our roster, the CRLMC.
Yes.
2018.
Yes.
I will restore the CRLMC.
Yes.
And CRLMC also I will dispose it up.
Yes.
Right up. Yes, right up. Right up. For the reasons stated in the application, the CRLM, the same is allowed. Allowed, and the CRLMC number
692/2008.
CRLMC number 692 of 2018 is restored to its original file. The CRLM first of yesterday, CRLM IRA 141 of 2014. The CRLMA has been filed. You have not given a reason to file after the delay of 536 days. 36 days. Although in the application no sufficient reason is shown. However, Mr. Maharaja on the main petition has argued to establish that there is prima facie case. In view of the fact that he has a prima facie case on merits, I am inclined to condone the delay and hear the CRLMC. Delay condone. Delay condone for the reasons stated. For the reasons stated. Come to CRLMC. CRLMC is 692 of 2018. In this petition is agreed by the order dated 18/9/2017, passed by JMFC Ranpur in DR case number 212 of 2013, whereby NBW against the petitioner has been issued. Mr. Maharaja, learned counsel for the petitioner, in the taking me to the charge sheet, has submitted that the name of the petitioner, name and parental of the petitioner, though are the same. However, including the address. Addresses are different. Name and parental is same. Now, name and parental.
Only name is same. No parent. Only name same.
Actually, that the name and parental.
Name of, although the name of the present petitioner resembles with the alleged accused in the charge sheet. However, the parental and the address reflecting in the charge sheet is completely different than the original parental, the original address of the petitioner and the parental name and his father's name. To establish that he has relied upon relied upon relied upon his degree certificate.
Degree certificate, I card,
Relied upon various documents, including degree certificate and the identity
date
card,
of certificate,
identity card issued by the State Bar Council. State Bar Council, and what else?
date of certificate,
Aadhaar card, etc.
a board of secondary education.
Board of Secondary Education, etc. etc. Learned Council for the Mr. Maharaja further submits that the petitioner is a practicing advocate at
Ranpur Bar Association.
Ranpur Bar Association. He has nothing to do with the crime. The name of the accused reflecting in the charge sheet may resembles the name of the present petitioner. However, the parental and address are completely different. So this is the case of mistaken identity. Therefore, he on the aforementioned ground, he seeks indulgence of the court and quashing of the entire criminal prosecution, apart from the order dated 18/9/2017 passed by learned JMFC.
11/28/2023.
I am I'm not inclined to entertain this petition at this stage and examine the veracity of the evidence produced by the petitioner to establish the case of mistaken identity. However, I am inclined to quash the NBW issued against the petitioner and grant liberties to the petitioner to appear before the trial court.
Quashing my lord, may I say one thing? Because he is stating that I am not the because father's name is there.
He says it is a mistaken identity. So somebody to examine it. I am relegating him to trial court. Let the trial court examine it. Yes.
ଆଉ ଯୋଉ ଧର ସେଇ ଲୋକ ନାଁର ଗାଁ ନାଁରେ ଥିବ ତାକୁ ଆରେଷ୍ଟ କରିବ ଏଡମିଟ କୁ ଆସିବ ଆରେ ତା ଏଗେନଷ୍ଟ କିଛି
वो इन्वेस्टर को आसा लगा
I am for him only. I am doing it.
as against
For him. You can't do it because see, you could not find out who is the right person. Who is the lawyer? He is same, but he is practicing
से all that. So what
আমি মুভি বুঝ করে রেকর্ড দেইছি
सेटा এই
I don't know whether he may be nobody knows it.
ये ऑर्डर ଟିକେ ଦେଖନ୍ତୁ କାରଣ ଆରେ ସେକେଣ୍ଡ ସେଟା ପ୍ରଥମ ବେଲେ 18/7/2017 ରେ ଏନବିଡା ଗୋଟେ ଏବେ ଦେଇଛନ୍ତି 2-3
Now Ranpur. You go and tell all these things. Right.
ସବୁ ଜିନିଷ
On or before 10th of December. 10th of
warrant dated 2/8/2023 and that vote.
10th of December. 10th of December. Now लिख दो 18 and এটা কোন ডেট
so the warrant second warrant ଆମର dismissal है restoration
2/8/2020. Yes, 2/8/2020.
yes obliged
One appear.
yes
And till no court selection. Till then, till the 10th of December, no court selection.
সেটা তো হয়ে গেল সেটা ক্লাস হয়ে গেল দরকার নেই না সে ওয়ারেন্ট ক্লাস হয়ে গেল মোর সারেন্ডার করি মোর আইডেন্টিটি প্রুভ করিবি
ठीक है.
यस
ठीक.
86.
Both
the order you assume
CRLMC as well as CRLM, both disposal. Yes.
yes you assume last warrant date টা রিফ্লেক্ট করলে
हाँ, yes, sir. Yes, sir.
86.
Yes. 86. Nobody there. Pass over, huh? 87. Withdraw. Yes.
88.
Yes, sir.
It might not, it's an application for quashing the order of commerce on section 289 IPC. That is negligent handling of animals. My lord, the info the FIR story is, my lord, the dog of the accused persons bite, my lord, the two children, not two children exactly, one child and another man, and subsequently they are neighbors. They have settled the matter. They have settled the matter.
That, with respect to my learned senior lord, I am appealing for the information. I'm filing on Bhakala. The issue of settlement, my lord, is correct as my stated by my learned senior lord. Only what affidavit they must have to bring and record that affidavit regarding settlement.
What are the offences?
289.
289 compoundable.
Only 289?
Yes, madam.
And 338. Extra compoundable.
338.
So that 289 compoundable. 289.
No legal impediment.
Lordship, there is no legal impediment except since they have already settled the matter. Just a few lines, Your Lordship. The dog has a history regarding. The dog has a history of being vicious. He has already attacked 3 people. That's it. That's no more.
Your dog. His dog.
Yes, yes.
Then shall I take it up tomorrow?
They have to file an affidavit unless.
They have to file affidavit and appear through VC.
Tomorrow maybe happen. Then a joint affidavit kariye. They have to come.
Joint affidavit to file and appear and VC. I don't know what will do in the chamber.
Joint affidavit द्वारा कोई प्रेशर कौन होती है? मैं affidavit आदमी को लर्न वन करके देबे. It will not be accepted.
You do it and file it and VC appear through VC.
Yes, ma'am.
Friday. Appear through VC. You file the affidavit. Call to your chamber and get it done and file it. Yes.
I can't deny my lord.
And if you can bring them tomorrow, joint affidavit and take it tomorrow. Bring them tomorrow. They will give. They will file the joint affidavit also. I'll pass it out. The same thing.
Can she is a lady, my lord? Can she appear in VC? Both of them can appear in VC, my lord.
But how will they give joint affidavit? So, since they are coming to the court, they'll come here and I'll pass it tomorrow. Okay, tomorrow. Yes.
May I please your lordship? May I please your lordship? My lord, I am for the petitioner in this case. My lord, a case re first time notice hela pore opposite party paila pore modhya appear koleni. Tapore your honor further once again directed to issue notice. Whether they have appeared or not, I cannot say. If your lordship will permit me, I will put forth my part of argument today.
Sorry, I didn't follow you. Sorry.
First time, my lord, first time notice issue hella pore. Semane notice paila pore bhi appear kole nahi. So previous date re your lordship directed to issue further notice. Aji hearing pai dila semane asi chandi na nahi mu janini. If your lordship
today.
My lord, may I put forth my part of argument, my lord, if you permit me?
Yes.
My lord, this is a case under section 138 of NI Act, and before the learned trial judge, when the evidence was over from both the sides, complainant as well as accused, OP, before the learned trial court, it is a case under section 138 of NI Act, my lord. When evidence was over, accused filed a petition praying therein to send the amount and content of the check to the handwriting expert.
Yes.
And evidence was over from both the sides.
Yes.
Here, the learned trial judge rejected the petition in view of section 20 of the NI Act, that there is no relevancy of sending it to the handwriting expert when the signature is already admitted by the accused person in this case.
Thereafter, you went to revisional court.
No, so accused party went to revision against the order passed by the learned trial court.
That's what I'm asking. Yes, saying yes.
Then the learned trial judge,
now.
my lord, excuse me. Then learned session judge, my lord, totally ignoring the section 20 of the NI Act, allowed their revision. Hence, this CRLM has been filed. What section 20 of NI Act say? Let me read that particular section, my lord.
Yes.
So that it will be very clear. When one person sign and deliver to another a paper stamped in accordance with the law relating to negotiable instrument then in force in India, and either wholly blank or having written thereon incomplete negotiable instrument, he thereby gives prima facie authority to the holder thereof to make or complete as the case may be. And in this context, my lord, I have filed a decision of the Honorable Supreme Court, recent decision, Annexure 5 may be perished, my lord. Annexure 5 I have filed, my lord. The recent decision of Honorable Supreme Court comprising of Justice Y. Chandrachud and S. Bopanna.
Yes.
The heading of the decision I am going to read, my lord. A drawer handing over a check signed by him is liable unless it is proved by adducing evidence at the trial that the check was not in discharge of a debt or liability. It is important, my lord, now. The evidence of handwriting expert on whether the accused had filed in the detail in the check would be immaterial to determining the purpose for which the check was handed over. Therefore, no purpose is served by allowing the application for adducing the evidence of the handwriting expert.
Yes.
My lord, when signature is admitted by accused, it is clear in the section 20 of the
Where has he admitted the signature? Where from I get it?
Yes, my lord. Yes, my lord. Just a minute.
Yes, I understand. Come to page 13.
Order
Come to-
passed.
Okay. I understood it. Come to page 13. 13 up for the your paper book where he has filed the reply to your application. There he admits at para 2. Right now. Petitioner is agreed by the judgment dated 6/12/2000. Notice was issued to opposite party number 2. Despite service, none appeared for opposite party to appear in the previous date as well as today. Today. Therefore, the matter is heard in his absence here. Right out. Petitioner is agreed by the judgment dated 6/12/2023, passed by Sessions Judge Sambalpur, whereby in Criminal Revision 7 of 2023, whereby the judgment, whereby the order dated 24/4/2023, passed by Civil Judge from JMFC Sambalpur in ICC case number 381 of 2018 had been upset. The opposite party number 2 had moved an application before the court inter alia seeking to send the exhibited check and the promissory note to the handwriting expert for the opinion as to whether the signature in the check and the promissory note is the same person and written by one person, that is the accused, or not. The trial court by order dated 24/4/2023 by detailed order rejected the prayer made by the accused opposite party number 2. The accused opposite party number 2 assailed the aforementioned order of 11 trial court before the revisional court by filing Criminal Division 7 of 2023. The Sessions Judge Sambalpur by the impugned order has allowed the revision and set aside the order of 11 trial court, thereby allowing the accused petitioner to send the check and promissory notes for handwriting opinion handwriting expert report. The petitioner being the complaint in the present case is agrees and has filed the petition. The counsel for the Mr. Aravind Das, the counsel for the petitioner, has relied upon section 20 of the NI Act. NI Act. 20 of NI, and also relied upon and the judgment of Hon'Ble Supreme Court reported in 2022 live law bracket SC 714. In the Honorable Supreme Court in the judgment of Oriental Bank Supra Supra has inter alia ruled as under para 4 and 17. Para 4 and 17. The reading of the provisions of NI Act and coupled with the law laid down by the Honorable Supreme Court, it is clear that once the issuance of check is admitted by the accused, who has filled up the check, particulars of the check is immaterial for the purpose of the offence under section 138 NI. The petitioner, the opposite party number 2, opposite party number 2 accused, while replying to the application, in his application, before the trial court, had inter alia award agent, either issue the page 13, para 2. Two, 3 and 4. 2, 3 and 4. The reading of the contents of the application is abundantly clear that the petitioner is the opposite party number 2 accused is not disputing regarding his signature in the check. However, he is doubting the not disputing the signature in the check. Rather, he very categorically stated in the application that he had signed the blank check. Therefore, the presumption under section 159 NI Act operates against the petitioner, apart from section 20 for the NI 20 for NI. In that view of the matter, the contention raised by the counsel for the petitioner deserves merit. Accordingly, the impugn order dated so and so, passed by so and so is satisfied. The criminal MC is allowed. Yes, allowed. Okay. 90.
Last proposition has a issue of notice for appearance of the official.
That is sufficient, sir. That is sufficient. Let us see. I will pass it over. Somebody may come. Let us see. Yes. Thank you. Yes. Pass over. Yes. 92. May I please visit?
Now, in this case, I have directed to add the informant as party, who has been added to note 5. But importantly, the actual informant has not been added, somebody else has been added. So I want to rectify it.
Alan counsel for the petition submits that inadvertently the informant could not be included as the opposite party in the present petition. He seeks leave of this court to include the opposite party. Issue notice to opposite party number 5. 5. Newly added into the yes.
Correct, of course.
Do it. Yes, sir. 93.
Item 91.
91
Password. Already acquitted.
Acquitted.
Judgment is.
Infectious. The petitioner has already been acquitted by the trial court by judgment dated.
Order that was 29/8/2024.
29/2024. Hence, the present petition was infectious accordingly disposed of. Yes. Thank you. 93.
My pleasure. Yes, on the last date, the notice issued to the complainant has it has been
Service sufficient.
Yes, ma'am.
Let us wait.
Madam?
Let us wait. Service is sufficient.
Yes.
Anybody may come after one password. Let's wait.
Notice was issued on 28/10.
Service is complete. Let us wait. Therefore, I am saying, let us wait. Anybody may come. Otherwise, after lunch, I will pass you. 94.
94 million.
Yes.
As per the lordship direction, representative 1 lakh 10 and also impose the approach to the council. This is a matter of settling within the package. And accordingly, the petition is reported 1 lakh 10 to the trial court and rest 1 lakh to general court. The option of the petition is required.
Yes, sir. So I am appealing to the
This is a matter of there are ruling ceremony. At the time of ruling ceremony, he has in the case of the informant that
We are giving the 2 lakh 2 lakhs and 20,000 has been used. So
I have sent it to mediation.
that is successful. That is successful. As the amount. In
You then supply the copy.
and also my
Weekly for hearing. Okay. I may include the present matter for present appeal for hearing in the weekly list. The petitioner is permitted to take soft copy of the records and photocopy of the same may be supplied to Mr.
The name may be reflected in the call list.
May reflect. Okay. Okay. 96.
96, my lord, he is filing one 394 to provide you. Appellant is dead.
Hello. The sole appellant in the present case has
Relay is there, relay will be congruent.
expired. Therefore, the present application is moved by the wife.
Yes.
Wife of the deceased appellant.
Yes.
Under section 394 to prosecute the appeal for the reasons stated in the application. The same is allowed. Amended memo of parties to be filed by tomorrow within 2 days. Within 2 days, delay also allowed. Yes. Next. 97.
97, my lord, these appeal may be listed along with CRLA 430. Another activity is there. Your lordship can have a glance with the judgment.
So for another activity is concerned, my lord, he is only convicted on section 7 of the PC Act and 2 months, my lord. He was the surprise of that, my lord. Petitioner is the government employee by the time, my lord, executive officer of the Panchayat, my lord. But I have filed case, my lord, for stay of conviction, my lord. That person, my lord, did not choose to file any case for stay of conviction, my lord, since he is a private person, my lord.
Argue on merits. Forget
For that, my lord. For that, I have
argument. No.
directly to supply the copy. I have already supplied the copy to him, my lord.
2-3 days back, they have supplied the copy. And this matter is had along with 430.
And sir, it is there. The certain aspects of this side, one who was functional, who was interested by the time. It may not be very interested for
In one case,
Who is appearing in that matter?
430 of 2016.
Who
Activity is there.
is appearing there?
That advocate's name has not been Mr. Sharma, Vijay Sharma.
Begin, sir. You tell him, I'll hear it today.
Tomorrow both the cases take out
Taken together.
small case matter. Complaint matter and the complaint matter not supported.
It's not small, you made it small.
Tomorrow matter.
It will be there in the list. Keep it in the list.
Another case matter. That case will track with this case matter. It will better come in supplementary matter.
Yes.
Tomorrow. 430 of 2016.
Day after tomorrow, supplementary. Okay.
430 of 2016.
Yes. You please tell Ligan.
Madam. Hello, I don't 94, maybe not 27 as per things.
27. Yes. 27 got there. Yes.
98 to 101. It hearing list as well.
2007, 17. Why has it come in supplementary?
It's order to stay conviction. I'll be hearing.
19 years ago, the government employee was not taken as a service benefit. No, taken as a next week.
Service benefit has nothing to do with it.
Because
Have to argue that. Ready argues. Give copy, get ready with all the paperwork and all. I'll hear
99. Let me take the soft copy of the trial court record.
You take, I do not pass any judicial order for that.
But if
You take it.
but if your lordship will direct for paper book for
You take the soft copy and come with the photocopy of that.
Okay.
I list it in the weekly. Take the soft copy and prepare a paper book and give it to the other side and come and argue.
98 to 101.
103.
103.
103.
My lord, I had earlier mentioned that the petitioner is suffering from blood cancer. Your lordship had directed me that lordship will hear this appeal in orders. And accordingly, I have given with all the people. Yes, I am submitting all the documents today, and I have
Suffering from
I will submit a small task.
He's suffering from cancer.
Your lordship may fix
We hear it and unnecessary.
fix it to Saturday working day.
ठीक है 30th.
30th.
I am submitting all the.
Hear it and finish it.
item 100 income some paper is already prepared, my lord. I'm sorry.
Yes.
I'm sorry.
Prepared.
Yes.
Give the copy, 100 paper book ready. Copy of the paper book supplied to the Vigilance Council. List it for hearing.
Listed in the hearing list, it is of the 2024.
Yes. Hearing list. Okay. 104.
105.
105.
102, my lord. My lord, 105 minutes.
102 also the same thing. It will go to.
Yes, I am serving all the copy of the depositions. It may be reflected, so that's.
Mr. Marana is saying something. He should do also.
You also pass the order to supply me the paper.
That is another matter. You are confusing with numbers. Yes.
So it may be added in the hearing list.
Yes.
2024.
Yes.
He has already received the copy, it may be added.
Yes.
Obliged.
105. My lord, day after tomorrow. Interim or continental. Mr. Bose.
That is by way of right. You will fix the date. Interim order also said everything.
Sorry.
2014 matter.
Yes. Mr. Bose out of station. Kindly.
Nothing. You just tell me what is this matter first. And when you appear in the court and submit,
Yes.
and then you are doing it.
Sorry.
You can't dictate the court. Take it up day after tomorrow, interim order continue. What is this? You must have some, how to address the court, you must learn. Repeat it. Repeat what do you want to say?
Day after tomorrow. Kindly.
Again, the same thing.
Kindly take on. Kindly take on.
Kindly, please or something else.
Just what
What is the, you tell me what is the case first of all.
the already compromise matter.
Compromise?
Yes.
Where are the party? Just see.
Here is also problem, my lord. In 15 years, can the pila choy This judgment is created.
We can carve the exception, and if the children are there and all, we have to save their.
Another case, your lordship told the morning also. So, why go to Ponder also?
But what? This is the reality. We have to take care of that situation only.
I'm sorry, also, both sides let us
Use it after 2 weeks. Okay. Yes.
106.
Okay.
On consent by petitioner, I am filing Bhula. On consent by petitioner, I am filing Bhula and take a number next week.
What is this case? This is pending since 2015. Change of counsel right now. What is this case?
Case is, my lord, case and counter case. They are SUCI members. While they are running in the, while they are traveling in the train, my lord, the police, there is some dispute with the police, and police has lodged the affair. Subsequently, they have filed the 1CC case, my lord. And in 1CC case, sanction has been, they are saying that the sanction has not been obtained, and the magistrate has taken cognizance against that. Yeah. For that, lordship has issued the notice for because it arises South to the complaint case. And the complainant also given a lawyer, my lord, for that.
And the stage operating.
Stage operating in the 1CC case.
What happened to the FIR?
The thorough dismiss page. FIR, my lord, investigation has been completed. Full instruction is not with me, but the fact remains there is FIR, and subsequently they have filed the.
No, but what happened? The FIR, there is no stay. The trial might have proceeded. So what to do? See, this of the stage operating since 2015. See, the stage operating from 15 to 2016.
Parties are here, my lord. And your lordship has issued the notice for that reason. And the offences your lordship may kindly say, what train the judge the dismissal. Perhaps for that reason, your lordship has issued the notice. And both the parties will inform the other party is
paying for informant.
Complainant.
Who is appealing complainant?
Sibo Kumar. Sankar Mishra.
Take the vocal now. File the vocal so entered appearance on behalf of the petitioner by taking consent from the earlier counsel and file the vocal. The same may be taken on record. None appears for opposite party. Number 2. In the present case, interim order of stay of the ICC case number 211 of 2015 has been operating since 15 to 2016. Therefore, in the interest of justice, last and final opportunity is given to the petitioner to argue the matter on the next date of hearing. If next date of hearing, and it is made clear that no further adjournment shall be granted.
You also peremptory
orders here, and made clear that no further adjournment shall be granted. And if the petitioner will not argue the case on the next date of hearing, the interim order passed on 15 to 2016 shall be vacated. Yes. 2 weeks old. Yes.
107.
107 euros.
Yes.
May I please the Lord?
Yes.
The privilege to be standing at this side of the addressing lecture. This matter was earlier being addressed by Mr. Mishra, Mishra, and on the last occasion he was trying to put the note in the case. It's question that criminal proceeding, showing the basis for the fact that this petitioner is statement.
Yes.
And the court is set for the
registered in 2014. What happened? The charge sheet might have been filed.
Right.
Then
It's gone to the court, my lord. And your lordship last occasion wanted. Your lordship last occasion wanted me to find out the status of the case. I've already called for the status. I can say from at least persons are also absconding and everybody will listen to him. The lordship is making one short of journey. I think got it ready and I think it's a lordship.
what are the offenses by the way?
The offenses are
379.
379 actually, but as far as present petitions also only this kind of stolen property. 379
Charge sheet filed for which offenses?
Charge sheet filed, my lord, that the background of the case is, my lord, one the rock was loaded with the iron.
I will take a call. Check it out for a second. FIR was lost against the 156 complaint case to SCG. FIR was lost against 379, 407, and 403 and 406. So then it will be nothing. You see, because this, and it was only against but against these persons are also named maybe the FIR. It was only against the driver of the truck.
Okay.
The aluminum load it was supposed to go from Hon'Ble to Howrah. On the way, the lost and the driver. The information the truck is lying in abandoned state in Howrah. After that, the file in 166, after this 156, FIR HG. When one master works where the main accused has been arrested, he was given a statement under 161 to remand the Bikhichi. From there, the implication arises.
Okay. It was abandoned. It is not recovered from you.
So, they were the authorities also.
This petition, sir.
They moved an application for retrieving the material.
Stolen property
how will you connect it? It is abandoned somewhere else. It is not from their custody position.
That both driver and the helper has been killed by the main accused person. For which charge sheet has been submitted under section 396, 364, 412, 120B, 201 of the IPC.
Okay.
They have committed docket, my lord. They have killed the driver and sold the.
So the main accused.
Then accused is sold to this person, my lord. For which, my lord, 412 he is receiver of stolen property and his godown was seized and he was implicated under.
Hey, was it recovered from godown?
Yes, sir.
It's not recovered from godown. It is abandoned somewhere else.
Right, broke nahi hai. Se jo material uda bikri karo.
Material was recovered from godown. Let us see that.
Nothing is recovered.
Okay, list for she wants some.
I'll get the latest statement of the
other papers. We'll see. Yeah. Yes. From 2016, the interim order jeopardy.
Yeah, interim order.
So this after 2 weeks. As peremptory order. Make clear that no further adjournments are due.
I will tell you that 2 weeks session.
2 weeks. We continue.
Actually, I'll definitely try to finish it.
Okay, parent. Okay.
108. Look, watching the FIR or in the meantime, what instruction?
Charge sheet has been submitted.
Already submitted.
Warrant warrant
tell me the order. Where is that order?
No, he has challenged.
I understand now. You have filed the charge sheet and NW has been issued. Court has you might have shown major absconder.
Again.
Show me the order. You tell me, I'll pass it over. Tell me, I'll stay that order.
No, that order will not available to me just now.
You tell me the date. Ask your client.
Look, Sahati is also not Vishakhapatnam, we not able to. I just to give a call. No response.
Process can dispose of the advertisement state that can be for a stay of the.
At the time of charge, I think all the points.
Yeah, okay. Where is that? Yes, the in this petition, petitioner has petition seeks quashing of the FIR in connection with GR case number 130 of 2016, arising out of Golanath Golan Thara. Case number 91 of 2016. Then counsel for the petitioner, the petition is filed on the ground that though the FIR was registered in 2016, the charge sheet has not yet been filed. On instruction, Mr. Janna, the counsel for the state submits that the charge sheet in the present case has already been filed on
15/3/2020. The IO Inspector B. Naik, Volmotor PS submitted charge sheet under section 272, 273, 120B, 34 IPC. Read with section 2024 of COPTA Act against the accused persons. Showing this petitioner is absconded.
Showing the petitioner is absconded.
No, not arrested. Showing the petitioner is not arrested.
Not arrested. Parent counsel for the petitioner submits that the trial court has issued non-valid warrant against the petitioner, but he is not able to certainly inform the court regarding the date on which the NBW has been issued. Be that as it may, I am not inclined to entertain this petition at this stage. Therefore, the same is dismissed with liberty to the petitioner to raise all the points before the court below at appropriate stage.
Lord in complaint.
Yes, this one.
Under this manner, I have apparently opposite to complaint case.
Somebody. On behalf of Mr. Osho Kumar, somebody mentioned. Yes.
Understand?
Yes.
I prayed for question of the proceeding under the Drug and Custody Act by prosecution of point of law. Non-compliance of section 24 of the Drug and Custody Act, that is mandatory provision, and also ground of limitation. Also ground of limitation.
Sorry. Yes.
And that is clearly covered by under Supreme Court judgment. There are two judgments I've got.
Section 20.
The proceedings have been passed only in that ground.
Which ground? Section
25.
25.
Section 25. Section 25, 3 and 4. Also, can you see section 25, 3?
Yes. Yes.
Section 25, 3 also can you see. The reports of government analysis, section 25. Any document purporting to be a report signed by the government analyst under this chapter shall be evidence to the facts stated therein, and such evidence shall be conclusive unless person from whom the sample was taken or the person whose name, address, or other particulars have been disclosed on section 18 has even printed the receipt of the copy of the report notified in writing the inspector of the court before in the proceeding, before which in the proceeding in respect of the sample of pending to impose to adduce evidence in controversy of the report. Unless sample has already been tested for or analyzed in the simple drug laboratory, where a person has under subsection to notify the intention to adducing evidence in contravention of the government analyst report, the court may also motion or issue discussion of the request either with the company or the accused to cause the sample of the two. So this is not applicable. But so there are three questions moving categorically requested sending it to the central laboratory. That has not been done. And that is the admitted from the prosecution except the judgment. That will also can see page 24. That's the judgment. Judgment will also can see.
196 in the case of Medicam United Limited and another versus Nubenco's drug inspector. In that case, and the case of present prisoner is different. My response the case of present the experience the magistrate, the federal, the present petitioner shot for another examination of the report. At that time, the drugs already been expired.
In this case, also same thing.
The same thing, my lord. Within 1 year.
That due to not laches of the present drugs introduced. Due to the laches of the present not.
Let me place this judgment. Let me place this judgment. My lord, they didn't do that. My lord, they read the judgment. Yes, let me place the judgment. There are also values for the my lord, may kindly say the one of the note of submission. Para I lord, may kindly say 18. 18, 1, 8. 1, 8.
Which paragraph of that?
1, 8, 18.
18.
Yes, my lord. That is 201. That of that judgment. 18. Second part, next page. Next page, the lordship, 18 judgment with the quoted the judgment. So lordship only the unique formal case, which was the case under the Insecurities Act, which has provisions analogous to section 25(4) of the Act. The court found that accused has indeed made a request to the inspector for sending the sample for testing within prescribed time limit and sorry, para 18 ballot. Flag 1. Judgment at flag 1. Medical and Biotech Limited versus Dog Inspector. Yes. What it meant? Para 18. And then the judgment 20 of the judgment. Yes. Yes. In unique public case, which was case under the Insecurities Act, which has provisions analogous to section 25(4) of the Act, this court found that accused had indeed made a request to the inspector for sending the sample for retesting within the prescribed time limit, and as this request has not been accepted, an important right has given to an accused has been rendered ineffective on which proceeding to be passed. This is what the court had to say. It cannot be again said, therefore, that the respondent in those appeals have been deprived of the relevant right to have the sample tested.
Come to the para 19.
The para 19.
Yes.
In the affidavit filed to the petition by Dr. B. Rao, Deputy Drugs Controller, and the argument before us, it has been repeatedly stressed that delay in sending the sample to the Central Drug Laboratory and had occurred as the appellant had avoided service of summons on it June 9/2005. This is begging in question. We find that there is no explanation as to why the component itself had component itself filed about a month before the expiry of
Continue to file the explanation.
But now 4 years after the file and immediately before the expiry it should have been filed. And the other judgment was 2018. The same principle. Same principle, but wrong facts. It is 27 when it comes. 27. Complaint petition.
Yes.
17. Sorry, page 17. I'm sorry.
17. Okay.
That yes, Lordship will find from the my date that I have given the date chart, but Lordship upon 22/8, that on page 17, that on 22/8/2007, Lalit Kumar Sahu, Division Drug Inspector so-and-so, the statutory sample of 4%, so-and-so, manufactured so-and-so. Then on 22/8/2007, annexure 4, the purpose of test analysis and one sealed portion of the so-and-so were sent to the government analyst of testing disability and drug inspector the blanket memorandum that is functioned that the government analyst of the drug testing have declared the above mentioned drug was not of standard quality from 13 test report number sponsor dated 15/7/2008 and Mr. 3. Then from the complaint,
I understand it, but show me when the shelf life of the drug has expired.
No, wait. But the
complaint.
The complaint, the date is not there. But I think the complaint. They filed it in 2012. They filed it in 2012. So they tried to notice to me just few days with the in the complaint you have to show me
that this is the date when the shelf life of the drug was expired. And prior to 1 month of that, it was not sent. So therefore, I am covered by this case. Simply from the company.
Election Council next page that after the government of Odisha Family Welfare Department next parameter.
Yes.
The notification understand the charge of dedicated officer that the person of the drug sample was declared on 22 and the case test was declared on the 17th of the government consultant was sent to the manufacturer of so. Yeah, when he said that now but on 26/7/2008 in response to this manufacturer has promised reply by the 24th 2008. But also 24th within 20 days. But that exercise after 25
See, if you want that this judgment is according to you is covered, then you have to show me that the shelf life of the drug was expiring in a particular
annexure to the complaint. Annexure complaint, but the election can see the annexure when you file annexure सबड़ा file annexure सबड़ा अच्छी तुमने reply से ना claim में लिखा है वो reply लिखा है तेरा फिर मैं reply categorically said that no pleading judge 31 in 2008 31 annexure file करो annexure क्षेत्र annexure क्षेत्र अच्छी then the trial court will look
So, see, if you have any document with you, and those documents you have to file it because
they are documents. I am dealing with documents only.
The order of the trial court where you have moved the application. You move applications there.
The trial court order. Trial court order. Where is that? Post 23. Online order that is also not legal permissible. Elections. Record people for taking cognizance for them to and the proceedings the question 2020 or the cognizance. Also because after some security and justify using 2 years. Then you move an application to trial court or
you are saying section 20 and all, 23 and all. That you can raise all these things.
Because of availability of provision that non-compliance
but that facts are different.
Facts are not different. Those election can be seen, and now we can compare the election can be seen.
Yes.
First one, and I think the started on the complaint, sorry, petition. First one.
But I can't decide on the basis.
No, I'm not.
Is a pleading.
The 4 years after the election can be secret to the chairperson.
Yes, my drug expiry for 4 years.
Now, even a 4 years charge it
Implicitly, I can't decide with you.
So, this long there and the election based on the record itself, then election condition.
You come out with a clarity from the documents which are there on record. You are the shelf life of the drug was expiring in a particular day. Preceding that day, 30 days preceding that, it was not.
Give me some time. Some time.
Nothing is coming clear.
Sorry,
nothing is coming clear.
Some date, my lord.
This is pending since
2017. But they have taken time number of times. It has been had before but
you prepare a note and give me.
Note I have already prepared, but I will prepare according to the prescription. Also, the judgment itself is clear and the interest. Well, Lordship, kindly check that 2 weeks.
After 2 weeks, entry model.
What's your like?
May I pardon?
Entry model.
May I have leave to mention
Pardon me.
157, that part heard matter, my lord, that appeal, it's come at 157. Subject to pleasure of my lord, had fixed last time at 3 o'clock. Any date, 3 o'clock, my lord, may fix that matter. 157, my lord.
Let it be there, it is in the weekly list, let it be there whenever you can come, my lord, I can take it
I'm
up.
there, my lord. I'm going to be there tomorrow or day after, whichever date my lord directs me.
Who is appearing on the other side?
The vigilance, my lord, they were supposed to be responding regarding that.
You are appearing that. Matter. This who is appearing? We'll see.
Yes. Well, I will be excused today, my lord. I have to go in a matter.
Today, any day.
Reminder 100. In this matter, the my lord has referred the matter to mediation center. In their manner, it is fixed to 30th.
Okay. Mediation, mediation going on. 30th, huh?
30th,
First week. Second week. Second week.
And 118 also has a pending.
Because it was said to mediation, due to their own non-cooperation and show the documents, they're not appearing before the mediation. They're just taking time, just to delay.
No, in mediation.
They are not appearing.
Where is there?
Date is there, 3 dates. On 2 occasions, they have been decided.
Okay. I am bound to appearing before the mediation center.
Let it be, then it will be.
I'll pass an order to that effect.
Yes,
I'll pass it. You send it to the mediation.
Yes.
You don't appear there and ask for adjournment. So therefore, I'll bound on you. I bound on you. What he says that you are not appearing before the mediation center. I'll bound on you to appear before the mediation center and administrator. I will pass you.
Parents have not received the notice, right?
Now you know now. It was sent to mediation. Now you know now. When is the date?
What is this? 2011. Actually, they don't know anything. Notice was sent to me and to them.
Who knows? Outside the code, he knows. Not inside the code. Outside the code. Okay, I'll bound on. I'll pass you.
CLNC number 3834 order date 5 11 ହେଇଯାଇଛି 6 11 ହେବ ଗୋଟେ modification ଟେ file କରିଛି
कल you पहले
My lord, in Canada, Mr. Mahapatra was at Delhi, but it has been cancelled. That is in next week, and that
150.
140. After my lord. Hon'Ble has taken the file to take the Xerox copy, my lord, and not returned, my lord.
150.
114, my lord.
40.
40.
So after 2 weeks?
Yes,
After 2
That's item 125 after 1 week.
125 entry model is there? Entry model is wherever entry model is there, give a short date. 125.
I'll check.
If entry model is there, next week or next week's 1 week or two after. Wherever there is no entry model, it can go to February. Okay. What are the offenses you said? 498. Okay. Petitioner has filed the present petition seeking quashing of the Talchua, Marine, Talchua Marine PS case number 9 of 2014. Parallel offenses under section 498 capital A 506 323 IPC. IPC, which has been initiated by opposite party number 2. the counsel appearing for the petitioner and opposite party number 2 conjointly submits that the parties are interested to settle the dispute through mediation. Hence, they request to send the matter for the High Court Mediation Center. High Court Mediation. Same model for awaiting mediation report. The coordinator has to fix the date and coordinator will fix the date and yes.
122. Item number 122. Can we take on tomorrow?
Sorry?
Item number 122.
122.
Can we take on tomorrow?
Tomorrow not possible.
Okay.
If there is any
interim order.
Interim order is that? Wait, let us see who is appealing. Let it come and show. Yes. Start. Sir, now pass over. 56.
The order of
56. Yes. What is this matter?
Matter is melody is challenge the order of
additional document.
cognizance my lord. And cognizance is clearly made out my lord. Lord, since kindly see the affair. 54506 and the middle portion of the affair my lord. Body size mokte mado marla body more down photo akhi photo ebong down oda jango pakhre bajla paki photo phul jaitila. Then corroborated by the other witnesses and also the complainant herself in the 161 statement. And he is in a stage of cognizance.
354 to 94. It is none appears for the petition.
Clearly, madam, your lordship may kindly see the statement of the victim, that is under annexure 11, page 11.
It was dismissed in default also. Thereafter, nobody appears. Madam, none appears for the petitioner, even on the second call. The matter was earlier dismissed for non-prosecution by order dated 17/5/2023. The petitioner moved an application for restoration. Accordingly, on 3/1/2024, the matter was restored. When the matter was taken up on 7/10/2024, adjournment was sought on behalf of the petitioner, which was then adjourned to 4/11/2024. Again, the adjournment was sought on that day. Accordingly, the matter is now was posted for the hearing today. None appears for the petitioner on the second call. In this petition, petitioner is seeking quashing of the order dated 9/9/2020, passed by GMFC Muri Bawla, whereby cognizance for offence under section 354/294/506/323 IPC has been taken against the petitioner. Mr. Jannar, and counsel for the state, has taken me to the allegation made by the complainant against the petitioner and also read out the statement of the complainant, Gauri Naik, as well as the witnesses Lalmat Darua, Pintu Kamar, Kailas Naik, perusal of the statement make it abundantly clear that a prima facie case is made out against the petitioner, for which the trial court has taken cognizance. Therefore, on merit as well, no case is made out. Hence, the petition is disposed of, dismissed. However, liberty is granted to the petitioner to raise all the points before the trial court at appropriate place. Yes.
59.
Yes.
Make the watch. And here the petitioner is a Gram Subak Rojuar Josana, my lord. GRS. And under the scheme, some amount is sanctioned, my lord, for construction of Pradhan Mantri Abbas Yojana. He has constructed a house, my lord, of Balaram Sahu. As per the rules, Balaram Sahu to select the laborers, and the payment has to be made directly to the laborers. And thereafter, my lord, all the payment was already made. Balaram Sahu made a complaint that no payment was made. Thereafter, my lord, for 10,800 my lord was shortage as per the allegation of Balaram Sahu, my lord. Lordship will find during the FIR was lodged, the case was registered under section 20 IPC. But the allegation is 10,800 was not paid. Therefore, the allegation can be 420. And immediately, my lord, after this allegation was made, immediately he paid the amount. He paid the amount, my lord. At 12:30, your lordship, my IDC, that document has been sealed. We paid the money on 5/11/22. And thereafter, FIR was lost. This is the document indicates, my lord. And my time my checkup. Why has he paid if he is not taking money? Pardon? Why has he paid? When the complaint is made, my lord, he paid. Where is the allegations of money or the commission offense? Se jo 4 জন को ଦେଇଥିଲା से 4 জন ଦେଇ ସାରିଲା ପରେ ସେ 4 ଜଣକୁ ସେ ସିଲେକ୍ଟ କରିଥିଲା as per the law ସେ ସିଲେକ୍ଟ କରିବ 4 ଜଣ ଦେଇ ସାରିଲା ପରେ ସେ କହିଲା ମତେ ଦେଇ ନାହାନ୍ତି ତାଙ୍କୁ ପେମେଣ୍ଟ ସେଇଥିପାଇଁ ଦେଲି being apprehensive ମତେ ମନାର କେସ୍ କରିବ ମୋ ଚାକିରି ଯିବ ସେଥିପାଇଁ ପୁଣି I paid them. Thereafter also FIR is maintainable, my lord. If the allegation is I have not paid and I have paid, it's not the yes, my lord.
That's it. So the charge.
That's it.
You are what?
And your lordship has when your lordship has kind enough to issue notice in this case, right? This state council.
It's directed to I will sort it.
Acha,
physically also remember say physically handicapped person after your lordship my friend was not there to state council. Your lordship is a physically handicapped and return with the amount. While the prosecution is continuing, he has also taken time to submit the license.
You see, sir.
Is a physically handicapped man will also remember.
Yeah. We should just see 58, na item? 59. Just see last order. Last order. Last order, just see. What have you written? Owning to the fact. Last order. Change the last order. Last order, the order is wrong. But I dictated owing to the fact that the matter is sub judice. Now it is written owing to the fact. Change it. Owing to the fact. And replace this order. Yes.
Other proceedings, my lord.
But the same arrangement. Same arrangement. Yes. Interim order. Same arrangement is there. Move application and correct it, huh? Owing to the fact. Yes.
Still to
get fixed.
That will fix. Yes.
Lord, the informant is the wife of the petitioner, and he had lodged the affair on 25/7/2024. Just after 6 days of the petitioner's husband has filed a case before the Honorable Family Court of Bhadra for under section 9 for restitutions of the conjugal rights. Where the informant had left the house of the petitioner from February 2024. allowing offense of February 2024, was lodged an FIR on 25th July 2024, just after 60 days of filing a case by the petitioner before the Family Court Bhadra under Section 9 for restoration of the conjugal rights. And please see the page number 18, and then she the internal saying that ସେ ମତେ ଗ୍ରହଣ କରିବାକୁ ମନା କରିବାରେ ମୁଁ ଆପଣଙ୍କୁ ଏକତା ଜଣାଇବାକୁ ବାଧ୍ୟ ହେଲି। But clearly before 6 days, that is 19 July 2024, the petitioners had filed a case for the Family Court Bhadra.
Yes.
And also, please see the last that page number 25. There is a mutual, they have tried to a mutual understanding, influenced by not mutual understanding, but they pushed, the Sarabans forced to come to the police station on 8 July 2024, and they forcefully they for the police station. And the implement that ଯଦି କୌଣସି ପକ୍ଷ ଏଥିରେ ସାହାଯ୍ୟ କରିବେ ନାହିଁ ଫ୍ୟୁଚରରେ ତାହେଲେ ଆଇନଗତ କାର୍ଯ୍ୟାନୁଷ୍ଠାନ ହବ। ଏଇଟାକୁ ମାନିକି ସେ ଜୁଲାଇରେ ସେ ଗଲେ
opposite party number written. Yes, Mr. Jena accept notice for the state. Issue notice opposite party number 2 written about 2 weeks. Yes, next.
80.
Yes. Service complete, na? Yes. What is this matter?
Lordship, the informant wife had filed a FIR against the husband and the friend of the husband. Lordship, the charge sheet has been filed against the present petitioner, who is the husband's friend, under section 376(2)(n), section 67 and section 67A of IT Act. And
what are the allegations?
The allegation is that the husband had committed upon the wife and also forced his friend. The friend and the wife were in relationship. That kind of allegations are there.
Notice was issue? Huh? Just issue notice, let us see. Issue notice.
So subsequently, a discharge petition was filed before the Honorable Lower Court. The Lower Court has discharged the present petitioner from section 293 and 67 and 67A of IT Act. They have been discharged. Only he is going to face the trial regarding section 376(2)(n). That is to be decided.
Okay, issue. Let us see. Issue notice. Non-appeals for the petitioner. Issue notice to opposite party number 2. Please accept notice for the state. Yes. 3-4 weeks for the 9.
Taken over next week.
Yes.
Taken over next week. Conducting council.
What is this matter? Is there any stay?
Challenging the judgment better
service.
Complete budget.
Despite service on the opposite party, non-appears for the non-appears. Let us count for the petitioner seek. Please the matter.
93.
I'm challenging the service is complete, Miller. I'm challenging the order under Annexure 1, Miller, at page 23, whereby charge has been framed. But
Yes.
apart from the grounds on merit, there is a procedural impropriety, serious procedural impropriety. Serious procedural impropriety in framing the charge, Miller. In 2019, the cognizance was taken after perusing the report. Miller. In 2019, the cognizance has been taken after perusing the records and all. But as per section 207 CRPC, the police papers and all.
Speak a little louder, I can't hear.
Section 207.
Speaker is on. Yes.
Section 207.
Section 207, the police paper also has been given to me on the date it has been filed. 2019, the cognizance has been taken. In 2023, on the day I appeared, the police paper was given to me, and on that very day, in a routine manner, in a mechanical manner, the court will have taken.
Where is the legal bar?
Can we see 239?
Session style, why is non-session, one session, everything has to be over.
It says after giving sufficient opportunity to the accused, the accused has to go through the police paper, he has to contact, he has to coordinate with his advocate. Thereafter, he can make submissions on those documents in a discharge. If on the very day I have been given the police paper, I can go through.
Have you told the court that please urgent time
participate and argue what that in many some of the judgments has been held. On the very same day it has been done, certainly it has to be. You have to tell the court that I have watched the paper today and read it. You don't tell and argue confidently. The court has taken a what to do. There are judgments which says the court has to presume that there has been a procedural impropriety on the very same day the charge has been taken. So
first of all, show me when the paper was given to you. When charge is
page 23, page 23.
Yes, 23. 23.
Second paragraph. Copy of petitions supplied to the accused person. Learned advocate for the accused person and learned 23. Second paragraph.
Copy of
yes. Copy of the police paper is supplied to the accused person. Learned advocate for the accused person and learned APP are present. Hard on the point of charge. Here is the case record with reference to the charge sheet and other relevant documents submitted thereof. After going through the contents and
all these things,
yes,
but you will not ask for adjournment. At this stage, the PP submitted that the summons be charge sheet issued so. You have not asked
because
ask for adjournment.
But kindly turn to kindly see section 239 of the CRPC.
Yes, read it.
If, upon considering the police report and the documents sent with it under section 173 and making such examination, if any, of the accused as the magistrate thinks necessary, and this is where I put after giving the prosecution and the accused an opportunity of being heard,
where from I will get, that's what I'm asking, where from I will get the community in order, the opportunity was not granted.
That's the duty of the learned trial court, but he has to see that there is a court.
Where does the statutory bar that on the same day paper is given, the court can't proceed?
What I am trying to submit is, if this procedure has been adopted, then there are certain decisions which are reliable.
On the same day it can't be done. From the impugn order, it is very clear that you are being heard. From the impugn order, it is again clear that the trial court has perused the entire document, which is part of the charge sheet.
I have not right,
but you have given opportunity, you argue.
That's I say it's mechanical.
What is will not help you. The obligation on the court is opportunity has to be given to the
exactly.
For whom, yes. And the perusal of all the documents raised by the police before framing of charges.
But
he has done it.
What
and you are agreeing the same day it has been done.
Yes,
same date can be done. Same date can be done. What?
Yes,
what big thing?
In this case, the facts page 201, paragraph 2.3. What was the facts? 2 points, 3 lines.
Yes.
Paragraph 2.3, page 201. Right top. Is the page number?
201.
201.
Yes.
Paragraph 2.3.
Yes.
Appellant was arrested on 4/2 and after completion of the individual charge sheet was filed on 13/2. In the court concerning the case was committed to the sessions on 18/2. The case was posted for 19/2. Can you mark this date? 19/2 is considered whether the charge is framed or not.
After committal.
Yes, madam. Now can you see?
Yes.
Paragraph 21.
21. Yes.
No case, sir.
In the present case, amicus curiae.
Appointed on 1923, will come at the same date.
Yes.
And on the same date, the council was called upon to defend the accused at the stage of framing the charges. One can say with certainty, like kind of this word, one can say the amicus curiae did not have the sufficient time to go through. One can say with certainty, the presumption,
amicus curiae was appointed that day.
Yes,
that presumption, but you were there, you have been appearing in this case.
I am appearing but without the documents.
What do you say?
Lordship, moreover, not a single iota or line has been provided that whether he has asked for time.
That I have asked, you read something, but see what he says is, this judgment partly helps you in the sense, on 18th it was committed to the sessions.
Yes, Lord.
On 19th the matter was fixed for hearing. On that 19th, since nobody was appearing for the accused, court appoints someone as amicus curiae and proceeds and frames the charge. The Supreme Court says that the 19th, when the amicus curiae was appointed, it is obvious that he might not have got sufficient time to argue. That's what he says. But here case is little different in the sense, it's not a case of amicus curiae appointed on the same day. Because the procedure is once you appoint amicus curiae, the document has to be given to amicus curiae and he has to read the file and all. But here is a case, a lawyer has been appealing, already appealing. This is the situation. This is the situation.
Perhaps I can only see the direct formula.
Yes. But these are not ratio division, in fact.
But I can't see the down below. I can't see. One can say
provisions. Provision concerning 227 and
227, which is carrying it to 239. Contemplate framing of charge upon consideration of the record of the case and documents submitted therewith. And after quotation, hearing the submissions of the accused and the prosecution in that behalf, if the hearing for the purposes of these provisions is to be meaningful and not just a routine affair, the right under the said provisions to deny it to the appellant. In our considered view, the trial court on its own ought to have adjourned the matter, my lord. Without the, I'm just
where you said the para 23.
In our considered view, the trial court on its own ought to have adjourned the matter.
Obviously, because amicus curiae was appointed in the same.
What I am trying to submit here, amicus curiae appointment, here the point is, on the day when you are giving the papers of the prosecution, on that day,
I will give benefit of for this judgment to him and I will set aside and remand it back. You won't argue. Let him unnecessary wait. I'll set aside. Okay. Fair enough. Petitioner has assailed the order dated 11/9/2023, whereby charges have been framed against him for the offences punishable under section 457, 294, 354, 323, 506, 34 IPC. The learned counsel for the petitioner has vehemently has argued that on 11/9/2023, the police paper was supplied to him, and on the same day, the trial court proceeded to frame charges against him mechanically. The petitioner, being the accused, was not afforded sufficient opportunity to peruse the police paper so as to advance the argument on the question of framing of charges. He has pointed out section, which section you have pointed out? 239. 239 CRPC, which mandate the court to give sufficient opportunity to the accused for hearing while framing the charges. The counsel for the petitioner also relied upon a judgment of Supreme Court reported in 2019-20 ACC 196 Anokhi Lal versus State of Madhya Pradesh. In the said judgment, the Honorable Supreme Court, in a similar circumstances, has quashed the order on charge because the trial court proceeded to frame charge on the same day and by appointing an amicus curiae, the Honorable Supreme Court arrived at the following conclusion: para 21, 22, and 23. 2023. The case for that and the State Council submits that the facts of the case in Anokilan Supra is distinguishable from the case in hand. In the present case, from the perusal of the impugn order, it is abundantly clear that the petitioner has not sought for an adjournment. Rather, preferred to proceed to argue the matter on merits. Therefore, the trial court has not committed any procedural error by framing the charges by giving sufficient opportunity to the petitioner. I am not agreeing with the proposition. I am agreeing with the proposition propounded by the counsel for the petitioner and disagree with the submission made by the State Council, particularly in view of para 23 of the judgment in Onoki Lal Supra. The Honorable Supreme Court has categorically stated that in the said judgment that the trial court ought to have adjourned the matter so as to afford sufficient opportunity to the accused to argue the matter on the question of framing of charges. In view of the provisions of law cited at the bar, provision of law, in view of the aforementioned provision of law and the judgment cited at the bar, I am inclined to allow the petition, set aside the impugn order dated 11/9/2023, passed by JMFC Burville in so and so, and direct the trial court to hear the petitioner and the counsel for the petitioner, counsel for the accused, and the prosecutor afresh by giving afresh and proceed with the matter. Proceed with the matter. With these observations, petition is disposed of. Yes.
Deeply.
Yes. Give opportunity to go argue. Yes. Yes.
124.
Yes.
Okay. Mention.
No, what happened? No. We were there where? 90?
93 passport complete.
And what about other matters?
Now.
Once you call, you don't know,
111.
111. What happened? 111.
No, please.
Despite 110 over
110 over
111 now. Yes. Yes.
In 111 also there is specific noting is that no report has been received from the IHC Dhamnagar PS regarding service of notice upon opposed by 228 also. Here is the case arising out to protect person lordship. 228 is the private state authority, but in the defendant is private party also. But my wrote letter to the concerned police station, Dhusri also. But facts remain that the sale is 228, but they are working now in different stations lordship. Therefore, the inspector in IAC is not able to contact them.
All of them are police vessels.
The lordship, 228 is the some of the SCF and other is the forest range officer lordship.
All range officers, ex-range officers. Yes. Serve them.
Now they are working place.
But who will serve?
Lordship,
Lord sir, that's the order dated 25/9/2024.
Yes, yes, I have already intimated the
Right on. The order dated 25/9/2024 for serving the opposite party number 2 to 8 by the IIC Dhamnagar PS has not yet been complied. Land Council for the state seeks one more opportunity to ensure service on opposite party number 2 and 8, 2 to 8. Leave the matter after 3-4 weeks. Interim order to continue. 4 weeks के बाद देखो entry mode to continue.
130.
Yes.
May I please, my lordship? I am appearing in person, my lordship. My lordship, last time about the passing of the affair, and also state had taken time to take the instruction of all the cases which is lost against
Yes.
the cases.
You have any instruction?
Yes, sir.
Yes.
Here is, your lordship, here is the case, the opposite part number 2 is arising out of a private complaint, representative 2, your lordship. The 2 is the necessary party to advocate the matter and lordship. So far, here is the case. It's clear case of adult against the present petitioner lordship for offense, alleged offense under section 447 to 94, 50634, your lordship. I am reading the statement, your lordship.
Yes.
More name Gatsuda merit, your lordship.
No, what is the instruction on merit you are going? Or something else happened?
My lordship, property is mine. I am in the house. Outsider entered into my house, my lordship. I have lost complaint in the police station. My complaint is registered. Again, counter case is registered against me, my lordship.
OP2 is the owner of that property. OP my responsibility.
But ROR, he has filed ROR here. Just see the ROR.
Annexure 2.
2.
Yes, Lord. That was in a will when Rajinama has been executed, and the Rajinama was executed by the
What happened to the FIR laws by you against them?
That also, I have no idea. Last time also, you have
That's FIR Annexure 6.
Annexure 6.
She has filed also a cross FIR.
Yes, sir.
NR6, Annexure 6.
Yes, sir.
That is FIR number 291. What happened to that FIR? Investigation is over.
291, your lordship.
291.
Yes, your lordship.
291.
285 has obtained instruction lordship 290.
That's what last time I said, that to get instruction, what had happened to the FIR filed by her against the accused person.
Yes. 291 is concerned, I have no specific instruction. 285 is the justice will file your lordship.
No. You have to get instruction in all the matter. Let me call for the state submits that he has not got complete information instruction in the present matter. Hence he seeks adjournment. Least the matter on 730. After 2 weeks. After 2 weeks. Interim order to continue. Call the IO and ask about it. She is a lawyer. And ask what exactly has happened.
Yes, specific that.
And try to find out the way out and solve it.
My lordship, when I am approaching to my property, my lordship, repeatedly they are lodging the affair, my lordship. Again, second affair also they have lost, my lordship.
Yes, I have seen that.
Yes, case number.
How many cases are you have filed against them?
I have filed 2 cases. And they have also
two criminal cases.
One is 302, my lordship, in the Chhatrapur PS. That is, they have killed my father, my lordship. First. Second.
What happened to that? What happened to that case?
They are under investigation, my lordship. That also last time obtained instruction to the state, my lordship. That also annexed, my lordship.
This you have to get to the entire picture because there are cases and all. Yes, improvement to control. Right.
Please.
116.
Yes.
Last occasion, your lordship called for a report from the special judge who is delay is attributed to whom?
Lordship 116 on behalf of Mr. Rajdeepa Bevra.
Lordships, I'm appearing online.
Yes.
Lordships, there was a direction of the last occasion to the counsel to ascertain as to why there was a delay on part of the prosecution in prosecuting the matter.
Report is there.
From the order sheet, your lordship will find that since from the date of cognizance, it is lingering at the on different pretest at the behest of the accused persons.
That's absolutely wrong. That's a very wrong submission being made. In fact, let me just clarify. The delay could be due to the fact that one of the accused persons, in fact, is absconding. And that is the reason, without splitting the trial, the court, in fact.
No, I'm just wondering, the last order, I asked the registry to get a report. The report hasn't come.
No, I said, potential.
Huh?
Order sheet potential.
Entire proceeding clear. That is.
Okay. Yes. Have you gone to the proceeding?
No, I have not. They have not filed any report. So, Lordships may direct them to file a report as to why there is a delay.
I think report, what I did is, I have asked them to send the entire proceeding. Show it to who is responsible for delay.
Absolutely, Lordships, because I don't have a copy of that. That would be before this honorable court.
Visible. Oh. What is this? Where is the proceeding? Where is the proceeding?
No, ଦେଖନ୍ତୁ ସେଟା ଥିବ ତଳେ ଥିବ ଅର୍ଡର ସିଟ୍ ଦେଖନ୍ତୁ ପୁରା ତଳେ ଥିବ ଅର୍ଡର ସିଟ୍ ତା ତଳେ ଦେଖନ୍ତୁ ଲାଷ୍ଟ ଅର୍ଡର ସିଟ୍ ଯୋଉଟା ତଳ କୋର୍ଟରୁ ଆସିଛି ଯୋଉଟା ସେଟା ନୁହେଁ ତଳେ ଥିବ ହଁ ସେଇଟା
Is there? Fine.
Order sheet last.
Yes, order sheet is there. The entire order sheet and the entire file is there. From trial court it has come. Now you check it up and address. Your briefing counsel can make a note of it. The persons to the order dated 22/10/2024. The learned special judge Vigilance Cuttack has transmitted the entire proceeding and the record of the case, record of PR case number 83 of 2012. Mr. Beoria, learned counsel for the petitioner, seeks an adjournment to go through the entire proceeding and the papers submitted by the special judge Vigilance Cuttack. Leaves the matter.
Since he has already appeared in the trial, and he has every right to go, he can obtain the certified copy from there and verify them.
But it has come. Let us see why I'm not. Why you certified copy and all.
In fact, if I may be permitted to make a submission, since he is making such a submission, the court's order was that he should find out as to why there was a delay. He cannot now put it on my head saying that I will apply for a certified copy and I will ascertain as to what the delay was, why the delay was occasioned. He should have been, Lordships, doing that. And he
You can see and tell you responsible. You can just take it up to the record and just see.
Since case is lingering, it must be within another of the appeal.
I'll put it after 1 week or 2 weeks.
2 weeks.
2 weeks. 2 weeks. Entry not to continue. The petitioner is permitted to inspect the record. Inspect the record. Without application, also you can inspect the record. Yes.
117.
Grateful, Lordship.
Then, my lord, I've come for quashment of the entire proceeding in vigilance year case number 54A of 97 pending in the court of CGM Cutter in the light of section 300 CRPs. My case is that I want to be tried for the second time. Second time for the same offense, for the same transaction, one FR, same accused.
Yes.
And these are amounted in violation of section 300 CFPC.
Yes.
Here, my lord, I am the sole accused in vigilance PS case number 3497.
Yes, sought for quashment of the proceeding, not filed the charge sheet.
No, he says that he faced the trial and is already acquitted.
Yes,
my lord.
300 is concerned.
My lord,
300.
So for 300 CRPC is concerned, that is in respect of same offense. Here the he is facing trial.
Case
he has faced trial in section 7 and 8 of the EC Act. Now he is facing trial under section that is 468, 471, 477.
What is his case? I don't know. I'll have to just see.
He is saying that.
No, from one transaction, one incident, if many offenses have taken place, you can't try him for every offense one case?
No. There was two charge sheet. One was tried for EC Act offenses and he was acquitted there. And now he is facing trial under section 468, 470 and IPC offenses in another case. And now charge has already been framed. The case of 2005, 2000 of the year 2098.
2000?
No, sorry, 1990.
97.
26/5/97. And the charge has already been framed. Trial is going on. At this stage, he has sought for quashment of the proceeding. He could have challenged upon the inception. At his acquiescence, trial was continuing.
My lord,
case is delivering. So he cannot take the plea now. He's saying that without filing the charge sheet, how can I?
May I make a small let him file a counter, my lord.
No counter, you should. Both the cases are arising out of the same.
The same offense. Lawful like same offense. Yes, one. That was and then he was so accused.
FIR is it annexure 1. Just show me. Kotak Vigilance Division case, 34 of 1997. Yes.
468, 471, 478.
Yes.
EC Act 7/9. My lord, this amounted to vigilance GR case number 54 of 97.
Yes.
54 of 97.
Charge sheet, show me charge.
My lord.
Charge sheet.
No, charge sheet is not there. The charge has been framed. I have been acquitted in that case. I'm coming to that. 54 of 97 was transferred from the court of CGM Cutter to the court of special judge ADJ Kendrapada. That was the special judge court. And the first charge sheet that was with the special court and all the document that was given transferred to that court, it had the IPC offenses as well as the EC Act offences.
As so many charge sheet, then only I will come to know this. If there was go step by step. No. FIR was registered.
My lord.
Charge sheet is filed. Cognizance is taken.
Yes, ma'am.
Charge is framed.
My lord.
Trial happens. This is the sequence.
Yes, ma'am.
You show me what happened, where the sequence has broken.
Yes, ma'am.
Charge sheet for that,
the entire order should have to that is in bulk.
I don't know you have to convince me, I don't know.
I'm coming to you.
Bulk or whatever. Unless you tell me how.
For a moment, I can.
Yes, of course.
If I simply explain it like this, that 54 of 97, which was pending for the court of CGM Cutter, I am here for 54A of 97. That was transferred to the court of special judge Kendrapada. It was tried in the court of special judge Kendrapada. The charge sheet, which was sent along with the documents on transfer to Station Court Chandrapada, consisted of all the offences. Those, all that one, but my learned said as a.
সেটা পাইবি ଚାର୍ଜସିଟ୍ ତ କୋଉ ଚାର୍ଜସିଟ୍ ଥିବ 2ଟା ଯାକ ତାର ଯିବ।
Before the Lakshmi hearing, that in that case, the court framed charge under section EC Act, 7 and 9 EC Act. I was acquitted there. They came against the order of acquittal. This honorable court in the leave application, leave was dismissed. My order of acquittal is in force. Thereafter, 54, I don't know how, it was still lying, but we were all, there has been changes in advocates because so there are lapse of so many years.
I think yourself is not clear.
No, I am very clear, my lord. I was conducting that case.
You tell me then, if the charge is, see, the charge sheet is filed for IPC offence as well as the TCS offence.
Yes, my lord, that is good.
And charge is framed only on the TCS offences. And then insofar as the IPC offences are concerned, we are charged. Charge is not framed. See what I could at face.
Document simply see the page 40, Annex 5 series, page 42. It is the objection to the petition for drafting of this proceeding, 54A.
Yes.
The written objection of vigilance.
Which paragraph?
Paragraph 2.
Yes.
The initially preliminary charge was submitted by the IO on section 7 and 9 EC Act with 468, 471, 478A IPC. Charge sheet number 35. It is 16/10/98. Thereafter, IO had submitted supplement charge sheet under section 468, 471, 477 AIPC. White charge sheet number 49, dated 24/11/98 as per instruction of Arison.
Yes.
The first charge sheet had gone to with 54 of 1990, which consisted of both EC Act as well as IPC offences. And the court preferred to take cognizance and
what is the 34 of 97? Come to page 39. The document which you are referring to. Read para 2 and para 3. First 2 lines. Para 2.
Yes, para 2.
Court of Vigilance PS case number 34 of 97. Next para 3.
Please.
Is the same thing?
This is one affair. This is same affair.
You are not clear. Try to be clear and forget the charge sheet.
I'm not getting my lord.
You are not getting what can I do? I was supposed to be because I don't know your case. 34. You have to make me clear.
37 of 97.
You see, you do one thing. You prepare a chart, a date chart, and record whatever you are saying so that we can, reconcile that with the.
I was waiting for this counter because that was order.
In the criminal case, what counter?
When the order is there. Order.
Forget about counter. You show me a document, in same case, I'll pass it. In same case, I'll pass it.
It was same case, my lord. I will prepare the document.
But you tell me how will I get?
I will prepare it.
Because saying same case will not be
because it will complete.
Charge sheet also.
Yes, ma'am.
File the charge sheet. File the charge sheet. Land counsel for the petitioner seeks 1 week time to file the copy of charge sheet and a list of event list of date of events. Date of events. This is matter for hearing after 2 weeks entry not to country. Yes. A list of date and events to write down and annexure, corresponding annexure.
1 week time.
1 week time. Yes, after 1 week.
Model. Yes.
118.
Submission was made that we are not present on the last date in the mediation. There was no notice from the mediation center to my client.
The only thing is, now you know about mediation.
Tomorrow it is fixed.
How do you appear?
Yes, yes.
Mr.
He will appear. Why we had not received notice? I am so
Deliberately there about all right now. He's saying. He's trying to contact him over telephone. Also avoid it. This will be the attitude and the mediation will not. Exactly. Wait. Let us see. Because now a senior counsel is appearing. And he knows the date. Tomorrow I have the ground down. So what should I only see on 6th? He don't appear. Then has referred the matter to mediation on order date 8/10/2024. The opposite party, court party, have deliberately not appearing before the mediation. Deliberately not appearing before the mediation. Mr. Shantanu Shodagi, senior counsel, appear for the opposite party and submits that the matter is fixed before mediation center tomorrow. That is tomorrow date. So and so. And undertake before this court that his client would participate in the mediation process. Awaiting the mediation report, leaves the matter after. Let it liable. I'm not disposing of it. This week list may continue. Well, see, mediation, I'll tell you. Mediation means you go with open mind. Don't, if there is a pressure of this court and mediation will open, it doesn't happen, then it is a different story. We can't pressurize the mediation center and everybody.
Hostility. Next week, tomorrow, my lord, I don't understand what's the meaning of mediation.
Enjoy the entry order and leave it after 1
We file a false case, one case in criminal code, another in 138, or each.
If the counsel is appearing for both the parties will have this attitude, how will you settle this?
It is, no, this hostility, this fire, and totally inaccurate.
Fire in the court is all right, not outside.
Hostility.
In the mediation center.
To my client. And my lord,
false submission. 1 week after. Unfortunate person here is able to make like this.
For last 5 years in the other side, no, you started everything with no, my lord. Now you have come the other side, you start saying yes, my lord.
What 5 years, 2.5 years?
190.
Yes. Yes. Who is appearing? No, the DK Father. Oh, who's dialysis? The counsel appearing for the opposite party sought an adjournment on the ground that his client is not disposed of. After 2 weeks. Yes.
120. 120 we kept on Friday, my lord. All the petitioner appeared through virtually.
What is this matter?
A compromise matter. Already they have informant already appeared. Some of the person has not appeared. That's why your lordship keep it to today. Your lordship keep it to on 22nd.
Are you really serious?
No. 506, 294, 323.
That's right, but see, 1, 2, 3, 4, 5, 6, 7 dates.
7 days, it was listed yesterday. They have tried to come, but court has not functioned. That's why lordship keep it on Friday.
So Friday is last opportunity, yeah?
2 p.m.
You bring, no problem. Let them come at 12 o'clock if they are coming.
Actually, they will appear.
Let them come once.
Yes.
Through virtual or whatever. Oh, Friday, huh? Don't have to examine.
Yes.
122.
What happened 121? Adjournment to?
Second is file count along with the chair.
Counter.
After solved today, we'll file a rejoinder to that and we'll
Okay.
file for concerning March.
Okay. ये preemptory order करो. There was a preemptory order here.
Yes, yes. There was a.
So counter file today.
Yes, ma'am.
Okay. Counter file today. Copy of advance copy of the counter is served on the counsel for the petitioner. At least the matter on 2nd December. See, last time also there was a peremptory order. Whereafter, before also, it is made on 4/10/2024, a peremptory order was passed, and peremptory order passed. But the counsel for the vigilance has today filed the counter affidavit. Advance copy of the same is supplied to opposite party petitioner. Release the matter on 2nd December. Along with CRLMC 3344/24, and it is made clear that no further adjournment shall be granted in this matter on any ground whatsoever. Entry model.
We'll file rejoinder.
I have said that rejoinder, if any, to be filed, has to be filed before, has to be filed within 2 days. Within 2 days. No adjournment.
2 days before to file.
Within a week time. Today we are at
2 days before to 2nd of December.
Okay.
Yes, okay.
No, by 28th, huh? By 28th, okay, 30th, huh? By 30th of November, 30th by November, huh? That was like it made clear that no further adjournment shall be granted in this matter on any ground whatsoever. Okay, entry mode to continue. Yes.
122.
122.
Kindly be pass over.
120. What pass over at 3:30? You tell me.
This paper is supposed to be listed along with the 7622/24. That's why I could not put that.
Okay. I'm just adjourning. Entry mode to continue. Yes.
123.
Least along with right down. No? Least this matter along with so and so entry mode to continue. Yes.
No instruction from the petitioner about the settlement matter. Taking your loss in a disposal on that term.
123.
138 at the NIM.
You are for accused.
I am for the accused petitioner.
Right. The counsel for the petitioner submits that he has no instruction. No, the present petition was filed. That means that mediation has failed. And the present petition is arising out of a complaint under Section 138 NI Act. Petitioner has assailed the order dated 13/9/2023 passed by JMFC Culture in ICC case number 11 of 2023. Whereby cognizance of offence under Section 138 NI Act has been taken against the petitioner. The matter was referred to mediation by the order dated 8/2/2024. However, the mediation has failed. Thereafter, the matter has been listed before this court for hearing. On many occasions. Today, certain counsel for the petitioner submits that he has no instruction from his client. In view thereof, the present petition is dismissed. Yes.
126.
Yes.
126.
One 26. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 126. 1 What is this matter?
My lord, 126 Union of India is the party.
What is that? None appears for the parties. In the interest of justice, adjourned to after 2 weeks.
127.
This application is filed by the former in-laws. Now the wife is the wife has been early divorced. Opposite partner early divorced, and when she was divorced on mutual consent, she has taken 4.5 lakhs. And while filing the divorce, a joint petition was filed at page 27. Your Lord,
service petition. Opposite party number 2.
appear करचंती.
Appear.
Chitran was filed.
Yes.
Yes. Let's see page 29 para 13.
29.
Page 29 para 13.
Yes.
The OP hereby promises and
husband got acquitted.
Pardon?
Husband got acquitted.
Joint petition. No, this is joint petition between the husband and wife.
Okay.
The while taking divorce, that petition.
Yes, yes.
Husband paid 4.5 lakhs.
Where is that?
Para 13. This is joint petition.
Opposite party.
The OP hereby promise and undertakes not to proceed further and fully compromise the case instituted by her in GR case number 1344.
I got it.
Bloods.
I got it. This is what? This is a settlement term.
Settlement and the she has mutual consent divorce has been allowed, which is at annexed 2 series. Page 17 starts from page.
Where are the accused persons?
Pardon?
Where are the accused persons?
Accused persons are the petitioners.
I know that, but they should be here. It is a quashing petition.
Tomorrow it's not prohibited there in the
VC. They should appear in the VC. Then we will come to the court.
Let's
ask them to appear in the VC.
I'll talk to them.
Tomorrow, day after. Day after.
Day after.
Day after.
At 2 p.m. Let's fix a time so that it will be
2 p.m. And let them appear through VC.
If they don't come, they'll appear through.
Yes. Okay. Yes. Release the matter. Day after tomorrow. Yes.
At 2 p.m.
128.
Ask them to appear through VC so that I'll ignore the presence of complainant. Because complainant has already filed an affidavit before trial court. Why do we turn necessary?
Affidavit before the file.
She has not been interested. She has taken their permanent money. And she has undertaken to the trial court that the criminal case has to be stopped.
She will not prosecute with the other criminal.
So she will never come. She has taken her money. But the accused has to just appear and so that I can quash it. Day after. Online there they may be. Yes.
128.
On behalf of Mr. Chairman, I pray for a passover.
What passover at this stage? What is this matter?
Lordship was directed for CDMC. And my lordship, there are two petitioners. From second petitioner, I have one antecedent, criminal antecedent. And my lordship, as per 164 statement, she was raped by the two of the person.
At least of 2 weeks. Yes.
129.
Yes.
It's a case to which the lawsuit was had directed the state council for those who charged in my lord. It's a case where I filed an application that petitioner is an accused in a case which was instituted at the instance of the president of the trust and the petitioner is the secretary, my lord. So allegation was made that these petitioners in the capacity of the secretary has a misappropriation amount which belongs to the society or which FIR was lost in case was registered under section 420 and other offences, my lord. And investigation was taken up, my lord. Documents were seized, charge sheet was prepared, and ultimately the charge sheet was filed. But it is found from the charge sheet, my lord, a document which is the most important document, that is the resolution book of the trust, which would indicate the expenditure and income of the trust, that was deliberately withheld. So I filed an application for discharge of the accused. Who is?
One thing is that they have filed section 91 of CRPC for the documents they need. My lordship, can we have a glance to the order itself? Where the learned court has not denied to the document.
Yes.
She only says that in the initial stage, I can't able to provide this document. Because my lordship, as per section 207, my lordship, or 207, my lordship, supply to the accused of a copy of the police report and other documents. When it says that, when the period of trial comes, then they have filed two petitions. First is discharge petition, and another petition is 91 of CRPC. So learned court says that after the discharge petition, then
Suppose while arguing discharge petition, this document is essential for them. Yes, you may find some difference out of it. Then how can you deny? Exactly, we argue. How can you argue? Is the 227 petition without full document? You have to give the document. Then only we can argue.
But section 220 is correct.
Forget about the technicality. Why don't you tell me whether this is part of the captive? You give it. Simple.
Yes, ma'am. But
Thereafter they will argue on discharge application. You just tell me whether this document is a form part of the charge. Yes. It's a form part of the charge. He has shown me the form charge. If that is there, give me a copy. Finish. I will allow this application. And thereafter, after getting the copy, you will read and argue on charge.
Yes, ma'am.
Whatever you want to argue. Huh? So, shall I allow it?
Yes, ma'am. Because my lordship, as per section 227, says that if upon consideration of the record of the case and the document submitted here therewith, and after hearing the submission of the accused and the prosecution in this view, the judge considers that there is not a sufficient ground for proceeding against the accused, he shall discharge the accused.
Just a question on this.
Me,
How will we come to know? All the documents form part of the charge sheet. Have to look into whether charge is made out or charge is not made out. It has to be looked into.
therefore, my lordship, they have
You must give the copy. If it is there, then you have to give copy.
they relied upon the state of the DN party.
Directly.
And there is a direct Supreme Court decision also, Lordship has seen in the last time I know.
Yes, that.
But they said that if the document has been seized and if it is related to the case, they must have filed the document in the court and I am entitled for a copy.
Yes.
They have not filed, they cannot withhold the document if they are seized during investigation, I know.
Yes. Shall I allow you will speak instruction?
Yes.
Yes means what? Allow. I am allowed.
State council, the custodian, yes.
Now this is the from state council.
Yes.
Now for the sake of argument, you should not argue. You are supposed to assist the court.
Yes.
Wherever there is no material, they should say yes. This is fair enough.
Supreme Court judgment also, they said that before it can be produced when the trial is going on. But now it is they have filed a discharge.
Give the copy and finish it up.
I have also that state of
Paragraph 9, your Lord's may kindly see. Thus it is clear, while ordinarily the court has to proceed on the basis of the material produced with the charge sheet for dealing with the issue of the charge. But if the court is satisfied that there is material of sterling quality which has been withheld, it's important, which has been withheld by the investigator, prosecutor, the court is not debarred from summoning or relying upon the same. Even if such document is not a part of the charge sheet, it does not mean that the defense has a right to invoke section 91 because the satisfaction of the court at the stage of charge.
Point to point, yes. In this petition is agreed by the order dated 5/9/2024, passed by CJM, Assistant Sessions Judge Nabarangpur, in GR case number 929 of 2019, whereby his application under section 91 CRPC has been rejected. The Mr. Naik, senior counsel, 4/11/2024, para 2 and 3. Para 2 and 3, you will para 2 and 3, let you. 4/11/2024, para 2 and 3. Mr. Naik, land counsel for the senior counsel, has relied upon a judgment. Where is the citation?
Citation, my
Citation. Equivalent citation is there. Equivalent citation. Equivalent citation is there. 2018, 2 SCC 93. Nitya Brahmananda versus Sri Gopala Reddy. Renewal, not renewal. Relying upon para 9 of the said judgment, Mr. Naik submits that the document which is obviously the part of charge sheet as reflecting from the seizure list of the charge sheet is a sterling document to substantiate his case while framing while pressing for discharge. Therefore, his application under section 227 CRPC seeking discharge, which is pending, cannot be heard without supplying the document which is material to the defense, material for the defense. Para 9 for the judgment to itself. Para 9. You are relying upon something.
That
Statement. Which paragraph?
Paragraph not written. In the judgment.
He is relying upon the same judgment. Para 9.
My notion I just mark in this paper.
But he is relying upon that same judgment. No, this is a different one.
Yes, my notion.
Different one. Sorry. State of Orissa versus Devendranath Party.
Yes.
Which paragraph, by the way?
My lordship, kindly have a look. Page number 5. Page number 5, my lordship. First, second paragraph.
Different context.
Not different context. Section 91, my lordship, kindly have a look.
Section 91.
My contention is only that prior to not going to discharge petition against only, then they will pass the order in the discharge order.
No, this, if you read this judgment also goes in his favor. This is page 5, third paragraph. In Maharashtra versus Piasara.
Last paragraph I have.
As opposed to me. These are not formed part of the charge sheet.
Yes.
Document which are not formed part of the charge sheet cannot be relied upon. You can't ask for it. But you see the charge sheet, your charge sheet at page 14. You yourself have seen it. This judgment says any document which is not formed part of the charge sheet cannot be demanded. Cannot be demanded. That's what. See, I just read. Please. You read your judgment for your understanding. I'm telling you. last two lines you read it, last Indian, right now, you read it. You can read it, Article 21. Huh?
Yes.
Since that would result in the accused having to face the trial for a longer number of years, despite the fact that he is liable to be discharged, if granted an opportunity to produce the material and on peril thereafter by the court. That is, the document is not there, production of the document is not permissible. But here in a case, you would have seized it. Yes. Which is part of your charge sheet. You won't apply the copy. How can you do that right now? Right on madam's name. What is Mr. Marana appearing for the state fairly submits that the document sought to be supplied to the accused petitioner has indeed been seized by the police as reflecting from the charge sheet. If it is formed part of the charge sheet, then under section 207 CRPC, petitioner being an accused is entitled to the entire copy of charge sheet along with the documents, having said that, she has relied upon the judgment of the Honorable Supreme Court passed in the state of Orissa versus Devendra Nath Padi, reported in 2005, 1 SCC 568. He has relied upon the following paragraph of the state judgment. The following paragraph of the state judgment. The document sought to be produced by the prosecution, sought to be supplied by the prosecution under section 91 of CRPC was formed part of the charge sheet, formed part of the charge sheet. Therefore, the trial court has committed a procedural error by rejecting the application of the petitioner under section 91 CRPC, particularly because of the reason that the application of the petitioner under section 27 CRPC for seeking discharge from the seeking discharge has been is pending. In that view of the matter, the impugn order dated 5/9/2024 passed by so and so is passed, and the prosecution is directed to supply the copy of the document. Copy of what? What was that?
The resolution book of the trust.
Copy of
resolution book of the trust.
The copy of where is that? Charge sheet कहाँ गया भाई? Charge sheet copy of
Resolution book of
resolution
book of
नहीं, copy of one register of Ma Bhandaragharani Educational and Charitable Trust containing 90 pages. Bracket loko, which is appropriately described in the property description of in the charge sheet dated 26/12/2020. Proper description is there, huh? Yes, allowed.
Obliged. Ordinance.
It's good.
130.
Then April against the order of confiscation. And on the last occasion, as I was submitting Lordship may kindly recall, I have pointed out that the amount of disproportionate assets was 5 lakh and odd. And the amount of case that was recovered from my house. Even I panel into order to continue, Lordship. So that is the calculation problem that we. No, not calculation, Lordship. What I submitted is that the case and the deposits that were seized immediately, that amounted to much more than the amount of the DA. So there is no reason why my residential house will be attached. That is why the challenge was made. Yes, I understand. Interim order to continue. So none appears for State Council for the Vigilance. Mr. Moon appears for the petitioner, and the interest of justice adjourned. Interim order to continue.
131.
Yes. One 31 vigilance. Hmm? If their entry orders are operating unnecessary, these people are non-APS for vigilance. Non-APS. Weekly. This is weekly. Let it be there. Let it be there. Charge appearing, waiting for which item?
133.
33.
33, 34. That is also vigilance matter.
What is there?
Let
it retain.
Let it remain in the list.
Don't disturb. Tell Vigilance Council to be here, because this is the time when I can hear some regular matter. Waiting to reach exhaust the list, miscellaneous list, so that one to regular matter one can be here. And at this time only Vigilance Council is not there. Tell them to be there.
My lord, 132, my lord. We can adjourn at least. Last chance is given.
Note it down. Let it be there. I'll not take it up tomorrow.
The adjournment in lower court.